Am I perfectly audible to all the judges? Good afternoon, Your Lordships. This is Priyanshi Raj. I'll be the Counsel 1 on behalf of the petitioners arguing on two issues. Issue 1 with regards to the maintainability of the writ petitions, and issue 2 with regards to if these games conducted by the petitioner company are games of skill and not games of chance. If your lordships are well versed with the facts of the case, the council seeks permission to proceed with issue 1. Your lordship, you're not audible to me. I'm so sorry.
Can you nutshell the facts within a few sentences?
Certainly, Your Lordship. Your Lordship, Midas Online Private Limited is the petitioner company that conducts online games like horse racing betting, rummy, poker, etc. on their online platform. They earn revenue out of it and they pay GST on it at the rate of 18%, which is the rate which is prescribed in the GST code for the games of skill. Later on, after 4 years, the GST department put show cause notices for 4 years for blaming the petitioner company for having short paid the taxes because these games are games of chance and not games of skill. Later on, the petitioner company comes up with different writ petitions under this Honorable High Court and submits their claims. Your Lordship, with regards to issue 1 of the maintainability of the writ petitions, it is important to notice that the respondents in their written submissions mention that an alternative remedy is available under the NCLAT. Your Lordships, it is essential to notice that even if IBC gives power to the NCLT to entertain an alternative remedy, the High Court's jurisdiction is not outstayed by it. The same is cited in a case of Embassy Property Development Limited versus the state of Karnataka, which was an honorable Supreme Court judgment. It says that in every matter where the High Court can prevail any authority, any other subordinate body, where the High Court thinks that the matter is in public matter, where the question is of law, the High Court can take the jurisdiction. Now, with regards to the petitioner's claims and submissions as to why this is maintainable.
What do you want the court to grant you?
Your Lordship, we want the Honorable Court to grant the maintainability of the writ petitions under this Honorable Court.
What relief would you want?
The relief we want is that, 1, we want the court to name these games as games of skill and not games of chance, thereby paying only 18% of the tax on admission fee received by the petitioner company. The relief is for the petitioner company because it is directed against the GST department. Yes, Your Lordship. Your Lordship, under Section 107 of the CGST Act, there's an alternative remedy available under the statute. It says that any person having any grievances under this Act can approach this particular section and or seek any alternative remedy. Certainly, Your Lordship. Your Lordship, I was about to answer your question, Your Lordship. Your Lordship, an appellate authority does not exist in the state of Karnataka till the time the petitioners filed their claim. Till very recently, in 2023 only, the Lok Sabha has now decided to put appellate authorities everywhere to reduce the burden of the high courts. Yes, Your Lordships. In absence of that alternate remedy, the petitioners then submit that under Article 226 of the Indian Constitution, the High Court has the power to entertain these writ petitions, which is why they should be maintainable. Your Lordships, if you permit the counsel to explain the reasons as to why the jurisdiction is valid, or you want your counsel to proceed to issue 2? Certainly, Your Lordship. Your Lordship, with regards to issue 2, the issue is divided into 2 folds. First, whether these games are games of skill or games of chance. And second, then what is the payable GST by the company? With regards to issue 1, it is important to notice that all these games conducted by the petitioner company are game of skill. But to make that differentiation, we need to know what includes as a game of skill and what includes as a game of chance. In a landmark judgment of Dr. K.R. Lakshmanan versus the state of Tamil Nadu, which your respectable lordships can refer. Yes, Your Lordship. Yes, Your Lordship. Personally, the council feels that these games are solely game of skill, because whenever we play, for example, online rummy, in rummy, the deck of cards are final, which means if there are 52 cards being distributed to the participants know that there are n number of kings, n number of queens, n number of twos, n number of threes, and so on. The rules are clear that the participants are supposed to make 2 sequences. For that, they have to discard cards according to the strategy they need to form to make these 2 sequences. For this to happen, every participant needs to have the knowledge of all the cards present. Secondly, they need to possess that expertise and training to ensure what cards to discard, what cards to take, what sequence can be formed out of what cards, etc. In the lieu of the same, the petitioner submits that online rummy is then a game of skill.
Yes, sir. What about if it's a deal show?
I'm sorry, Your Lordship. I apologize, I couldn't hear you.
Yeah. Do you know what is a deal show? Since you said you know rummy, do you know what is a deal show?
Your Lordship, I don't understand. If it's this dealing of the cards?
Okay.
You're given 13 cards.
Yes.
13 cards are dealt for each player.
Yes, Your Lordship.
Then the 13 cards, when it's in your hand, even before the game begins, there are necessary numbers of sequences, whatever they are called.
Yes.
You've got all on your cards, in your hand.
Yes, Your Lordship.
So where is the skill? Everything is given to you by chance, all done.
Yes,
So
Your
would
Lordship.
you still call it a game of skill?
Your Lordship, this is where the predominance test come in. The predominance test says that the games are not supposed to be exclusively a game of skill or exclusively a game of chance. It could be a combination of both. So here the petitioner agrees that certainly the dealing of the cards you get initially could be by chance. It could be by any anomaly of the chance. However, the further proceedings of the game solely depend on your skill to exercise that particular game and win in that particular game. Since the proportion of skill is more than the proportion of chance that exists in this particular game, it passes the predominance test and thereby is a game of skill. If your lordships are satisfied with the answer, the council seeks permission to move forward.
Well, we'll permit you to move on, but we will not tell you whether we are satisfied with the answer.
Certainly, your lordship. Your lordship, now if we talk about other games such as fantasy cricket, in this case, if we talk about the example of Dream 11, where you're supposed to form a team of 11 players from both the teams that are playing any particular match. For example, there's Royal Challengers Bangalore versus Mumbai Indians happening. In this particular game, if you want to make a team, you need to know what was the form of all these players, does the pitch report look like, is it supporting the spinners, it is supporting the fast bowlers, it is a batsman supporting pitch, etc. Which means you need to have a deep analysis, a deep knowledge of cricket and skills to understand what kind of team you want to make in order to earn money out of it. This means that no ordinary person without the amount of skills to perform this successfully can actually earn this, which means there is possession of skills and there is exercise of skills. In certain other examples, for example, horse racing, in this example as well, even if you're playing online betting on horse racing, which is happening on the petitioner side, you still need to know about the horses, their conditions, the jockeys, how they are trained, what is their breed, etc. The respondents might claim that it is very hard to know such things if you're not present in the game. However, it is crucial to note that all these things are easily available on the websites that conduct these games. Because they also want their participants to participate more and more, analyze more, have more statistical data, and then probably earn out of it even more because they want the participants to be engaged. Which means all the statistical data, irrespective of it being an offline game or online game, is provided to everyone where they need to exercise that skill, need to possess that skill, thereby passing the test of predominance.
Sure. One question to you.
Yes, Your Lordship.
Is there any chance of manipulating with the algorithms and the result is decided by someone else?
Your Lordship, there would be a threefold answer to your question. One, the 276th Law Commission report states that all these online gaming platforms have to call out all the bots, their algorithms, anything they are performing needs to be provided to the users pre-hand. It needs to be declared. But secondly, majority of these games can't have bots because these games are betting games, which means they need to put some money into it to earn out of it. There would be no bots which could actually put money into these games, which means the chances of having any kind of bots or the chances of any kind of manipulation in the algorithm is not possible with such laws existing in picture, and with the petitioner's company's incentive is to make sure that the game is growing, is to make sure there are more and more participants. When that is true, there would be less and less manipulation because it is in the business model of the petitioner company to be successful. If Your Lordship is satisfied, I would like to proceed. Thank you so much, Your Lordship. Your Lordship, in other cases like poker and all other games that are provided, the petitioner submits that the test of predominance is passed. All these games require the same amount of skill, the same amount of expertise, and same amount of training that needs to be possessed in order to be successful. Your Lordship, then I would seek permission to move forward to the second part of the, which is then the payable GST. Your Lordship, if we consider that there needs to be a proper code which distincts the game of skill and the game of chance. Herein, the petitioner submits that GST already has a distinction in it. The HSN code 998439 clearly states that games of skill are to be taxed at 18% on the admission fee, whereas games of chance on the HSN code 999692 are to be taxed at 28%. Here, when the petitioner submits and concludes that all these games are games of skill and not chance, they should not be taxed at 28% like the orders passed by the GST department, but should be at 18%. If Your Lordships are okay with this argument, I will proceed to the new fold of this argument. Much obliged.
You can say we are okay.
Apologies, Your Lordship. The second fold of this argument is that whether the GST is payable on the entire consideration received by the petitioner company or just the admission fee. Your Lordship, it is important to note the Bangalore Turf Club case versus the state of Karnataka that happened recently for the reasoning that the petitioners want to provide. The case divided the institution into two types. One institution would would invest into these bets, would earn out of these bets, and would also earn commission out of these bets. Such institutions are the bookmakers. While as the second type of institutions are totalizers, wherein they don't invest into these bets. They don't go into earning out of these investments. They merely facilitate the bets. Here, the petitioner company is only earning commission on the admission fee received by them from participants. The other percent, that is the 75% of the pooling fee, is an actionable claim of the participants which will go back to them as winning prize. In this particular situation, it is crucial to note that when this is true, the 75% of the amount is not the revenue of the company. It is not the profit of the company, and it is not retained by the company.
What's the definition of actionable claim in GST?
Your Lordship, in the GST Act, they have directed it, in section 2, they have said that the actionable claim definition is the same that is mentioned in the Transfer of the Property Act, which is where a certain amount is put into an intermediary as a debt which would be given back to them when that particular activity is over. With respect to the same, in the present case at hand, the actionable claim of participants is given back to them as winning money, which means all these participants are then paying taxes individually on the money that has been earned by them. In the present case, yes, Your Lordship.
You say this distinction is important. This distinction between 25, 75, one is actionable claim, other is not. Why
Your
do you
Lordship.
think that distinction is important?
Your Lordship, it is important because one part of the amount is earned by the company, whereas second part of the amount that is pooled by the participants to play, to bet, to win, to lose is by the participants and for the participants. So in order to avoid double taxation, which means the participants are already paying tax on their winning amounts, the company should not be then made liable to pay tax on the same amount which they don't even retain.
No, are you sure the winners are paying the tax? And which tax you are talking about?
Your Lordship, the winners are supposed to pay tax on any amount received on any.
Which tax was a part of the question?
Your Lordship, the council is not sure about that.
Are you referring to the income tax?
I think so.
If you are referring to the income tax, we are not concerned about that. That's an entirely different tax liability.
Yes, Your Lordship. However, if that is not considered, still the company is not liable to pay that amount of tax that on which they have no claim, on which they have
Just
no
as a
revenue.
follow-up, counsel, the definition of consideration under the GST Act, does it give you the leeway to bifurcate the payment into 25% and 75%?
Your
Can you
Lordship.
demonstrate that it is possible for a taxpayer to vivisect the payment into 25 and 75 as per the definition of consideration under the GST Act?
Your Lordship, no. The consideration definition does not provide this percentage of division that is made by the petitioner company on admission fee and the pooling fee. However, it is mentioned under Schedule 3, Entry 6 of the CGST Act that all actionable claims are exempted from tax except for lottery and gambling. In the present case, if these games are all games of skill, that means that they come under the actionable claim which is exempted from taxes. In the lieu of the same, if your lordships are satisfied with the answer, I would like to summarize and conclude the arguments.
But are you aware that rummy, if you go by other laws, is known as gambling, or in normal parlance, it's called as gambling.
Your Lordship, under the Public Gambling Act, under Section 12, all the games that are games of skill are exempted and are not called as gambling activities. Which means, if we prove, if the petitioners submit that all these games conducted by the petitioner company were games of skill, then it would not be considered as gambling under the Public Gambling Act. Thereby, the petitioners finally submit that the writ petition is maintainable under the eyes of the law by this particular Honorable High Court under Article 226 of the Indian Constitution because there was violation of principles of natural justice against the petitioner. Yes, Your Lordship. And secondly, all the games conducted by the petitioners are games of skill and not games of chance, merely because they possess the skill and they exercise the skill. And lastly, there is an actionable claim on the 75% of the polling fee by the participants, which is why the petitioners have no right over any income that is earned in that particular amount and thereby are not liable to pay tax on any of the amount.
They've issued show cause notice, isn't it?
Yes, Your Lordship.
Then how do you say that principal and act justice is violated? Because you are being asked to show cause, and you after you issue and show your cause as to why it should not be 28% but only 18%. And if the authorities are satisfied, they say it is 18%. So why do you say that there is violation of principles of natural justice?
Your Lordship, the Council would request to answer this in two folds. If I may please refer Your Lordships to para 6 of the Moot proposition. Your Lordship, I seek an extension of 30 seconds to complete the answer. Much obliged. On para 6 of the Moot proposition, it is mentioned, the last third line, that the GST department passed separate orders under the following sections. The show cause notices were under different orders and different sections. However, there were separate orders that were passed by the GST department on the 3rd of October. Which means on 3rd of October they passed these orders which were separate, which had a different issue, and they pushed the petitioner company to pay the penalty of 11,000 crores, which is such a...
Second set of orders are the orders that you mentioned on a particular day. They are under which provisions? What do they freeze in terms of liability?
Your Lordship, these orders are passed under Section 74, subsection 9 and Section 73, subsection 9, that is short paying of tax and fraud and misrepresentation and willful misstatement. Your petition...
So your submission is show cause as notice has resulted in that?
It is resulting... The show cause notices were passed under a different sections initially. The GST department never gave a valid justification as to why these orders were changed under different sections. What was the fraud done by the petitioner company? What was the willful misrepresentation? Nothing. On top of it, they were not given enough time but merely less than 48 hours to pay 11,000 crores.
That is on the payment of tax aspect. But the learned judges want to know that you were given patient hearing. The facts are very clear. You were heard in detail.
Yes,
That's
Your
what the
Lordship.
principle of natural justice is. So, believe that that aspect you have not satisfied the court enough.
Your Lordship, if I...
One more thing, just
Yes.
I may into you. You said there show cause notice was issued under section 74, right?
Yes, Your Lordship.
See, when you say order was passed under a different provision, which was the provision?
Your Lordship, firstly, the orders were passed according to it being the game of skill and game of chance. That is Rule 31A3 of...
That is okay. See, section 74 is only a demand.
Yes, Your Lordship.
Okay. So that will result in an order. Now you said that they passed an order under a different provision. What is that provision?
Yes, Your Lordship. The fact sheet only states that the show cause notice orders were different than the orders that were passed on the day penalty was passed on. Secondly, to answer Your Lordship's question, the principle of natural justice is not cited or is not contended by the petitioners on just the behalf of the show cause notice. The principle of natural justice violation is contended on the fact that even an accused in the Indian Constitution is given good amount of time to seek some remedy, is given some amount of time to seek their lawyers, to seek an alternate remedy. This couldn't happen because in the time of 2 days, the petitioners could not arrange such huge amount. They did not have the time to consult their lawyers. And alternatively, the High Court was also on a vacation bench for 2 days. So before they could seek any remedy, the orders were passed against them.
Thank you.
Thank you, Your Lordship. It was an honor arguing before this court. If you wish, I would like to call my co-counsel. Thank you so much.
council hopes that he is sufficiently audible. Much obliged. Your Lordships, my name is Arush Sharma and I'm representing the petitioners in the present case. Your Lordships, if Your Lordships are satisfied with the contentions made by my co-counsel, the council seeks permission to proceed with issue 3 and issue 4 as outlined in the memorial submitted by the petitioners. Much obliged, Your Lordships. Your Lordships, in issue 3, it is argued by the Council of Petitioners cannot be classified as a secured creditor under the provisions of Insolvency and Bankruptcy Code. Your Lordships, in this slide, the definition of secured creditor is being looked at, which is given under section 3, subsection 30 of the Insolvency and Bankruptcy Code. Your Lordships, the said definition says that a secured creditor is a person in whose favor a security interest has been created. Furthermore, Your Lordships, if we refer to the definition of security interest as mentioned on page 41 of the compendium submitted by the petitioners to the Honorable Bench, it can be said that a security interest means a right, title, interest created or provided in the favor of a person by virtue of a transaction and includes charge. Your Lordships, if we emphasize on the definition and carefully examine the definition, it is mentioned that existence of a transaction is paramount to creation of a security charge under the Insolvency and Bankruptcy Code. Your Lordships, the same has also been referred in the judgment of BHEL versus Anil Gupta, wherein it was said that since the word created and since the word transaction is mentioned in the Insolvency and Bankruptcy Code, and further, the word transaction is also defined in section 3, subsection 33 of the same code, and says that a transaction is one which is an agreement in writing between the parties. Your Lordships, in the present case, it is then pertinent to note that there was no transaction between the GST department and the petitioner company. The transaction in the present case, which the Council of Respondents might claim, was the payment of taxation. However, Your Lordships, it is then pertinent to shed light on the judgment of Delhi Race Club versus Union of India, when the Honorable Supreme Court created a distinction between fee and taxes and held that taxes are not quid pro quo. Unlike a transaction, a tax do not provide an obligation on the GST department to provide any service to the petitioner. In that regard, it is submitted that the statutory levying of taxes cannot be classified as a transaction within the definition of a security interest. The second limb of the definition, Your Lordship, says that a security interest can also be created by virtue of a charge. Your Lordships, then it is pertinent to note that the Council for Respondent
interrupt your speech. Why do you think the department is saying that they must have prior charge or they are non-power security? Why do you think they would say that?
Indeed, Your Lordships. The contention of the department is twofold. The first contention that the department makes is that they have created a charge by virtue of the CGST Act. If Your Lordships may refer to section 82 of the CGST Act, it says that tax has to be first charge on property. The second reliance that the Council of Respondents then place is on the recent judgment of the Honorable Supreme Court of Sales Tax Officer versus Rainbow Papers, when it was held that the state of Gujarat was a secured creditor for the purposes of GVAT Act. Your Lordships, the Council for Petitioner would like to contain both of these issues through their submissions, if Your Lordships may allow. Much obliged, Your Lordships. Your Lordships, the Councils refer to section 82 of CGST Act for creation of charge. However, Your Lordships, it is pertinent to note that the same section is refurnished in page 57 of the compendium submitted to the Honorable Bench. And if Your Lordships may refer to the same judgment, it is mentioned that notwithstanding anything to the contrary contained in any law for a time being in force, save as otherwise provided in the Insolvency and Bankruptcy Code, tax needs to be first charged on property. Your Lordships, emphasis is placed on this exception which the CGST Act in and of itself creates for the IRS. Your Lordships, further, it is then pertinent to note that Insolvency and Bankruptcy Code has its own way of dealing with payments. The said mechanism is called waterfall mechanism under section 53 of Insolvency and Bankruptcy Code. Your Lordships, under the said mechanism, secured creditors are second on priority for payment, while government dues and all statutory dues are fifth in the priority of payment. Your Lordships, given that this priority of payment has been established by the Insolvency and Bankruptcy Code, then we may refer to the exception created in Section 82 of CGST Act, and it can be held that by virtue of that exception, tax need not be first charged on property for the purposes of IBC, which the Council for Respondents
How do you
have.
respond to the fact that an order is passed under the GST Act, under section 7374(9) on 3rd of October, and the order of the NCA, the IBC is not
I apologize, Your Lordships.
Much later. Much order of the NCLT is much later. Whereas the attachment by the department was prior to that.
Indeed, Your Lordships. Your Lordships, it is pertinent to note that in the fact sheet, the difference was merely of 30 minutes, and the attachment orders that the GST department has created does not allow them to become a secured creditor in and of itself as well. Your Lordships, it is then pertinent to note that once CIRP began, the department also filed to be a secured creditor in the present case, which means it is the contention of the department that they must be treated as secured creditors. However, Your Lordships, to answer your question, if a charge has been created prior to CIRP as well, the same does not hold priority over the waterfall mechanism which is mentioned.
Referring to waterfall mechanism in section 53,
Indeed,
that arises only at the time of liquidation.
Indeed.
This we are still at the insolvency stage. What is your problem if a resolution applicant is willing to pay the tax dues also? Why would you come in between the resolution applicant without giving it right? Do you want to preempt that the claim of the department should actually should not arise? So we don't think the waterfall mechanism can be incorporated into insolvency. There are two stages, insolvency and bankruptcy. 53 arises at the time of bankruptcy, as you may know. So whereas at the time of insolvency, it all depends upon a resolution applicant who is willing to take over the company with all its liabilities. So why would you prevent the use of the government?
Your Lordships, it is pertinent to look at the factual matrix in the present case. The NCLT has reserved its order much earlier for the 6th of October, and the reserved order was kept by NCLT. Meanwhile, while the GST department realized on 3rd October that the NCLT is going to pronounce a judgment on 6th and a CIRP might be imposed, they might lose out on the money, they hastily created an attachment charge within 2 days itself by passing the final orders under section 73 and 74. Your Lordships, it is submitted that within 2 days, they expected the company then to pay 11,000 crores to furnish the relevant documents and also challenge the order. Your Lordships, it is then pertinent to look at the reference made by my co-counsel that in the present case, there was no alternate remedy. And as it is stated on para 6 of the Moot proposition, the High Court was also on vacation for those 2 days. Given that the High Court was on vacation, given that no other remedy could have been exercised, and given that only 2 days were asked to repay this amount, it is clear that the intent of the GST department was to create a hasty attachment order so that they can be classified as secured creditors under IBC and can create a first charge without letting the dues of secured creditors prevail once CIRP is initiated under the provisions of Insolvency and Bankruptcy.
Is the department empowered to make such hasty attachment? Is there any provisions for that?
Indeed, Your Lordships. The provision exists in section 78, which says that the department may provide a time of 3 months for payment of any GST dues. The said provision also has a proviso, which is being relied on by the Council for Respondents, which says that the payment time may be reduced from 3 months if it is considered expedient in the interest of revenue, and the same must be furnished. Your Lordships, it is then pertinent to know that no reasoning was given for why the attachment order was made within 2 days itself. Why, even after passing separate orders, only 2 days were given for the company to respond, to pay the payment, etc., etc. And it is also important to note that it was those 2 days were also depriving the depriving the petitioner from raising a claim against the orders passed by the GST department.
Should department keep all these factors before making an attachment? Should they keep in mind if an attachment is made, we should also give time for the taxpayer to challenge it? Will that be practical?
Your Lordships, the intent of legislature behind Section 78 was the same, that a period of 3 months must be given for them to furnish all the relevant details. However, if it is expedient under the interests of revenue, then the period might be reduced. Your Lordships, it is then pertinent to note that they only exercise this attachment order so that they can prevent the claims of secured creditors from prevailing, and which is why they reduced in time. Moreover, Your Lordships, as a statutory department, the GST department should also keep in mind the principles of natural justice. Your Lordships, 2 days is a very less time to furnish a payment of 11,000 crores, to even consult the lawyers and create a defense against the final orders which has been passed by the GST department. Given that the GST department did not pay regards to any of these considerations, it can be concluded that the attachment order was hasteful and the said first charge should not prevail in the present case.
Since you raised the issue of intent of the legislation, do you know there is something called advance ruling under GST laws?
Indeed, Your Lordship.
Did your party, your client, at any time approach the department with for advance ruling about the classification and all these issues? Because ultimately it came out of this only. All our litigation now what we are discussing is for the rate of duty and the consideration.
Indeed, Your Lordship.
So both of these issues could have taken by applying for advance ruling. Did they make any time? Did they make an attempt?
No, Your Lordships. Your Lordships, the reason for the same and the reason why we came before this.
It's all right. So you did not explain this, just I wanted to know. Okay. So there was no, you did not apply for advance ruling.
Indeed, Your Lordships. Much obliged. Your Lordships, it is then further submitted that after the imposition of CIR, the councils then rely on the Rainbow Papers judgment. However, it is crucial to note that the Rainbow Papers judgment must be read in context of the statute. The same was held by the Honorable Bombay High Court in NRC versus State of Bombay, when the court said that while blindly applying the judgment of the ratio of slate of Rainbow Papers would not be correct, we must look at the statute behind the judgment and must decide it accordingly. In light of same, we must examine the statutes, Your Lordships. Your Lordship, Section 82, unlike Section 48 of GVAT Act, creates an exception for IBC. The same exception does not exist in GVAT Act, which is why the Honorable Supreme Court was correct in the Rainbow Papers judgment to hold that the Gujarat government might be may be a secured creditor under the provisions of GVAT Act. However, Your Lordships, the same ratio cannot be applied to the present case because under Section 82 there is an exception created for IBC. Your Lordship, to back my submissions, I would like to refer Your Lordship's attention to multiple judgments, one of which is Sundaresh Bhatt versus CBIT. Your Lordship, the judgment is given on page 78 of the compendium submitted to the Honorable Bench. Your Lordship, in the said judgment, the court was examining a pari materia provision under the Excise Act and the Customs Act. Your Lordship, the court held that Section 11E of Excise Act and Section 142A of Customs Act, both of which say that customs duty and excise duty shall be first charged on property, create an exception for IBC in the similar manner in which the exception has been created by the CGST Act. The same wordings by the legislature has been mentioned in the provisions. And in this judgment, which is an honorable Supreme Court judgment, the court has held that excise dues or custom dues would not prevail over the dues of secured creditors. They cannot, and the government under these acts cannot be treated as secured creditors.
What's the reason?
Your Lordships, the reason for that is that under IBC, there is a waterfall mechanism which is sufficient in deciding the priority of payments. The manner in which the waterfall mechanism does so is that in the second entry, in the second priority, it is mentioned that secured creditors may gain their claims as second in priority. It is then further mentioned that government dues are on fifth in priority. Your Lordships, in that case, when IBC is sufficiently providing for a priority of payment and a classification between government dues and secured creditors, an authority like Section 82 of CGST Act, which already has an exception for IBC, cannot override the provisions of IBC because of the exception given. Moreover, also because of Section 238 of the Insolvency and Bankruptcy Act, which is a non-obstante clause, which says that IBC would override any other act in case of any contrary or inconsistent provisions.
So what happens in case, they don't resort to IBC, but go and client and ask for property without resorting to IBC proceeding, without going to NCT and asking for insolvency proceedings?
Your Lordships, in case that the GST department decides, in the case the GST department would have decided to do so, which in the present case they have not, the treatment would have been different and it wouldn't have been constituted under IBC.
And then they'll be advised to withdraw that NCLT petition and then go ahead and check property.
Your Lordships, however, CIRP has already begun, moratorium has already been placed, which means the proceedings of IBC would be the one which would prevail in the present case.
Why would you even move this court counsel? I mean, if they have sufficient protection under the IBC and also before the NCLT issue, why would you trouble this court when filing this petition? They have effective alternate mechanism which could have been addressed by the adjudicating authority itself.
Your Lordships, the reason why even after the existence of NCLT, the councils have approached this Honorable High Court is because firstly there's been a violation of principles of natural justice as argued by my co-counsel. Secondly, Your Lordships, we also want the Honorable High Court of Karnataka to decide on the question of law, on the questions of law which are created in the present, which are mentioned in the present case. Your Lordships, in the case of Embassy Property Limited, as cited by my co-counsel, it is mentioned that the Honorable High Court may entertain a writ petition at its discretion if it feels that a public interest is being harmed, or if they wish to answer a question of law which might have an impact on the public interest. Your Lordships, it is then submitted that there are multiple platforms which are holding these kind of online games, and there are contrary judgments of different high courts classifying different games as games of skill and games of chance. Thereafter, we wish that the Honorable High Court of Karnataka also provide clarity on this particular issue and answer this question of law. Moreover, Your Lordships, the GST department has at multiple times tried to claim that they are a secured creditor or are they an operational creditor. This tussle has also created a lot of backlog for the GST department, but a lot of inconvenience for all the companies and the assessees, which is why it is also important for the Honorable High Court of Karnataka to provide an answer to this question.
Now that's by how many judges?
Your Lordships, the council is not aware of the same.
Maybe you're arguing before you're arguing. So what's the precedential value?
Your Lordships, regardless,
Go with that. Why should we say no, we'll confine our exercise of the restriction under
Indeed,
Article 226 only to cases where there is lack of jurisdiction, principle, justice. These are timely requirements. Why should we not confine ourselves?
Your Lordships, this is the judgment of the Honorable Supreme Court. However, even if it is a single bench judgment, which is lesser than the current bench, the Honorable Supreme Court still holds a binding precedent on the Honorable Karnataka High Court. Moreover, since it is a judgment of the Supreme Court, it holds much value for the Honorable Karnataka High Court, and the Council for Petitioners pray that the Honorable High Court side with the petitioners in the present case. Much obliged, Your Lordships. Your Lordships, moving further, in the case of Jet Aircraft Maintenance Engineer Welfare Association versus Ashish Chavacharya, it was held that Section 82 of Maharashtra GST Act, which is a provision which is pari material to CGST Act, would not allow the Maharashtra GST department to become a secured creditor because it is different from the Rainbow Papers judgment. Your Lordship, in this light, the Council would like to conclude by saying that the GST department in the present case is an operational creditor. Your Lordship, the backing for that is a bench judgment by the Honorable Supreme Court in Ghanashyam Mishra versus Edelweiss Asset Construction, in which, Your Lordships, the court held that in cases where the GST department or other statutory departments, can I claim an extension for 2 minutes? Much obliged, Your Lordships. In case where a GST department or a statutory due is claiming precedence, they will be an operational creditor because as defined under IBC, the definition of operational debt includes government revenues and also includes charges which are only payable when a company is in operation or is conducting day-to-day operation, which is why we must rely on the 3-judge bench judgment and classify the GST department in the present case to be an operational creditor and ask them to wait in order of priority as per section 53 of the Insolvency and Bankruptcy Code. If your lordships are satisfied with this submission, the council seeks permission to move to issue 4. The council will summarize quickly. Much obliged to your lordships. Your lordships, under issue 4, the council contends that the orders passed by the GST department are also arbitrary and illegal. Your lordships, in the present case, it is important to note that the GST department,
Which order you are talking about?
your lordships, the order made under section 73 and 74, the demand orders.
As I understand, I think there appears to be some confusion. There are two issues here. Please clarify this time and again. You're telling principle of not justice, natural justice was not followed. See, there are two issues here. One on order, consequently show cause notice, issued in section 74. Other thing is attachment of, after confirming the demand made on the show cause notice, then the recovery proceedings started under section 72 and 71. Which one you are talking about here?
Your lordships, in the present submission, both of these would be included and said that the both orders are violated and arbitrary in
Now,
nature.
you please tell me how principle of natural justice was violated when giving judgment in consequent issue of show cause notice.
Your lordships, if
No PH was given?
no, your lordships.
Without PH, they have passed an order?
Personal hearing.
PH is sorry, personal hearing.
Indeed, your lordships, the same was given.
No, I'm not talking about the attachment order on the sheet 70.
Indeed,
I'm talking
in
about
SC.
the issue. Okay. He answered.
May I continue, your lordships?
As against show cause notice, you have heard.
Yes,
There
sir.
is no violation of natural justice. As against
Indeed.
attachment, yes, maybe. The question is, why would you say that there is no natural justice even for the show cause notice?
Your lordships, the council submits that under the demand orders passed under section 73 and 74, the said orders are arbitrary in nature. The reason for that, your lordships, is that the orders were passed for different financial years under different sections. For financial year 2017 and 18, the department passed order under section 74. However, for all other subsequent years, they passed the order under section 73. The lordship's statutory difference between section 73 and 74 is that 74 requires them to prove fraud, willful misstatement and suppression of facts. 73 does not. Your lordships, in the present case, no contention is made by the department for proving fraud, willful misstatement or suppression of facts. However, even if the same has been made in argumento, the distinction is still arbitrary because they only wanted to invoke section 74 so that they can gain the benefit of extended period of limitation of 5 years. Because if they had charged under section 73 for first year, they would have exhausted the limitation period. Your lordships, however, for the subsequent years, they've charged under 73 or the order under section 73 only. Lordships, then it is pertinent to note that there's no factual differences between the business conducted by the petitioner company throughout the years. However, still arbitrarily, different sections have been charged, which is why the council praised that the orders may be declared as arbitrary. Your lordships, the show cause notices were show cause notices were filed for 4 financial years. Your lordships, there were 2 show cause notices. Indeed, your lordships.
Then, once the notice is already issued, automatically, department will ensure that there is no violation or anything, there is no need of section 73. Now you can say that when the notice is clearly issued, you can say that section 74 they do different as the issue.
Your lordships, the show cause notices were filed after a gap of 4 years. In the 4 years, there was no difference in the business, there was no difference in returns filed. After 4 years, they created a distinction and said that the order passed for the first financial year contained fraud, willful misstatement and suppression of facts. However, the subsequent years did not. Your lordships, it is then pertinent to note that had they interfered after the first year itself, they could have established that suppression of fact was established in the first year and further we could have passed in the 73.
Then are you accepting that the demand under section 70 was correct? Illegal?
Your lordships, the council is arguing that the demand made under section 73 was not legal as per issue 2, which my co-counsel argued, and the current issue is an inarguable issue. And even if the demand orders made were tenable under law, they were still arbitrary in nature and must be quashed by some. Since my time is over, Lordships, the Council seek permission to proceed with the prayer within 30 seconds. Much obliged. Whereof, in light of facts stated, issues raised, arguments advanced, and authorities cited, the Council for Petitioners humbly pray before this Honourable High Court that it may be pleased to adjudge and declare that, firstly, the 4 writ petitions filed by the resolution professional on behalf of the petitioner company are maintainable before this Honourable High Court. Secondly, that all the games operated by Midas Online are games of skill and the extra tax demanded by GST department must not be paid by the petitioner. Thirdly, that the GST department may not be classified as a secured creditor under the provisions of Insolvency and Bankruptcy Code. And fourthly, that the demand orders passed by the GST department be held as arbitrary and illegal. And or this Honourable Court may pass any other order that it may deem fit in light of justice, equity and good conscience. And for this act of kindness of your Lordships, the Council for Petitioners humbly pray duty bound forever. Much obliged, Lordships. It was an honor arguing before this bench.
The Council would like to seek permission of this honourable bench to call this bench collectively as your Lordships. Much obliged, your Lordships. Greetings to this honourable bench. This is the Council of Respondent in the case of Midas Online Private India Limited versus against the Directorate General of the GST Act Tax Intelligence, Bangalore. For the easement of this bench, it is imperative for the Council to brief the bench with the facts of the case. Thereby, the Council begs for 30 seconds as it is imperative for the side of the respondent to hear the facts of the case. Much obliged, your Lordship. Much obliged.
Please in your arguing time, please remember that. We have a few questions as well.
Midas Online India Private Limited, which runs its business in online betting games like lottery, poker, rummy, horse racing, etc. As being of the nature of chance, the company was responsible to pay GST at the rate of 28%, but was that too on total consideration, but was only paying and paid 18% on 25% of the total consideration. Meanwhile, when the company was declared insolvent by the NCLT after the application filed by an operational creditor, the GST department secured it claimed as a secured creditor in the Form B of the IBC 2016. The RB unnecessarily filed the writ petition in the Honourable High Court, and now the GST department is too armed up to defend its orders and attachment before this Honourable bench. If the bench is well versed with all the 4 issues, including the one with the maintainability as they have asked, the Council seek permission to move forward with the submissions. Issue 1. Issue 1. Whether the present case is maintainable or not. It is humbly submitted before this Honourable High Court of Karnataka that the present case brought in by the petitioner have no legs to stand and is not maintainable under Article 226 of the Indian Constitution. The Council will establish its contention in 4 folds. That the statutory remedy was available under Section 107 of the CGST Act. Second, the NCLT has jurisdiction over this matter. Third, alternative remedy has not been pursued. And fourth, and the last contention, that Section 14, Clause 1, Subclause A of the Insolvency and the Bankruptcy Code that is the power of the moratorium. Moving ahead with the first contention, the Council humbly submits that if as per the claims the petitioner that they had the problem with the orders passed by the GST department, then in that situation, before hurriedly approaching the Honourable High Court, the petitioner should have used their efficacious and statutory remedy available to them by approaching the appellate tribunal. As per the Section 107 of the CGST Act 2017, which provides any person aggrieved by any decision or order passed under this Act of GST may appeal to such appellate authority. The Council submit that such an efficacious and statutory remedy has also been discussed in the case of Radhakrishnan Industry versus the State of Himachal Pradesh, where the bench laid 6 principles regarding the same.
Your friends on the other side say there is no appellate tribunal and therefore that's not an efficacious remedy as per the Indian approach or that finance.
The company was working pan-India, and they could have gone to other appellate authorities as well. And more importantly, retrospective approach of the legislation should be applicable since statutory remedies hold importance to it. The council will be dealing this in the third limb as well, that the alternative remedies were not pursued. There exists a 3-tier mechanism. Under the IBC law, there exists a 3-tier mechanism, that is an adjudicating authority, the NCLT.
NCLT decide on the merits of the GST orders.
We are talking about GST orders right now, not about the third and fourth part.
Yes, Your Lordship. The respondent will argue on this matter as well, that even NCLT has jurisdiction over this matter.
When you say over this matter,
Over the matters whichever are concerned after the insolvency was declared by the NCLT.
orders by the GST authorities.
The arbitrary orders that were passed by the GST?
Arbitrary orders by the GST from
Oh, I'm so sorry. I apologize for it. I apologize.
we want you to respond to that no appellate tribunal is constituted. Therefore, the orders are the GST.
There is no interpretation required of the High Court or of any court in this matter, as the GST orders in this case determine the case which are to be covered, and hence there is no interpretation of any law is required. This case is just on the basis of facts, so no interpretation.
As they say, arguments say, we will assume these GST orders are arbitrary. We will assume appellate tribunals were not constituted at the time. What is the remedy for that?
The council.
If it is not
I ask for the repetition of the question.
What would be the remedy for the petitioner if there is no appellate tribunal and if they are agreed to that attachment? So they are correct in moving this court.
Are they?
No, they are
Why
not.
would you say no?
Because there is no need of any kind of interpretation of law in this
NCLT
case.
will the adjudicating authority be competent enough to decide whether these online games are games of chance or games of skill? Are they competent enough to do that? Because their prayer is also to say that it is a game of skill.
Yes, they are. The tribunal are competent enough to deal in this matter as well, as the formation of NCLT, which was brought to consolidate all aspects related to company and insolvency as per the IRAD committee report. The council would like to rely upon the Union of India versus R. Gandhi judgment of 2010, when it was explicitly observed by the Honorable Supreme Court that when a tribunal is when a tribunal is constituted under the Companies Act, empowered to deal with the dispute arising under the said Act, and the statute substitute the word quote-unquote tribunal in the place of quote-unquote high court, necessarily there will be a wholesale transfer of the company law matters to the tribunal.
This is not a company law issue. Whether attachment or the show-cause notice is issued does nothing to do with the Companies Act. This is the GST Act. The NCLT is meant only to deal with Companies Act or IBC.
NCLT has a wider jurisdiction.
You are conferring with jurisdiction because we are satisfied expect that it cannot be having the jurisdiction. Are you conferring?
And-
Parties confer jurisdiction.
In the case of Gujarat Urja Vikas Nigam Limited versus Amit Gupta, it was held that NCLT's jurisdiction is as wide as to try matters related to insolvency. Therefore, it should be applicable to determine the position and the claims of creditor as well. As in our case, that is the main issue of our case. If the honourable bench is no further questions, the council would like to seek permission to move to the fourth contention, that is the moratorium has been released under section 14, clause 1, subclause A of the IBC. The council would like to take the honourable bench on page 4, paragraph number 6, if the bench is with me, where it has been mentioned that the moratorium has been declared as of 10:30 a.m. on 6th of October 2022. Therefore, we submit that once section 14 of IBC has been incorporated, which provides for moratorium, which is a period where no judicial proceedings for recovery, enforcement of security interest, sale or transfer of assets, or termination of essential contracts can be constituted or carried or on in any other court or judicial body. With these contentions, the Council of Respondent humbly submits that the petitioner cannot avail any writ under Article 226 of the Indian Constitution, and thereby this present case should stand non-maintainable by this honourable bench. If there are no further questions.
One question to you. Like when you are served the show cause notice, had you quantified the tax liability, or you had only mentioned in place of 18% or 25% of the collection, you would pay 28% on the whole amount. But interest is compensatory in nature. Penalty is penal. For what you can charge penalty only when you can prove suppression of facts, willful misstatement, and intention to evade or committing fraud. Without proving any of that, and also serving a general show cause notice, how can you expect them to pay the taxes or agree for your show cause notice? How can you pass the order on 3rd of October and freeze their account on 5th of October?
This is because the company has frauded the government, and further this question will be in detail will be answered by my co-counsel in the fourth issue. If the council seeks permission to move forward with the second issue, whether these games provided by the company are actually a game of skill or are of chance. It is humbly submitted before the honourable bench that Vidas Online Games was dealing with nothing but online betting games. The council would like to request the bench to please refer to the first paragraph of the fact sheet, that where it is clear that the company was involved in business of online betting games like rummy, poker, fantasy cricket, horse racing, lottery, etc. The very first paragraph itself clears that the company was operating game of chance to run their business. Now, with the due permission, the council would like to take the bench to the third paragraph onto the second page of the fact sheet that states that thanks to the online gambling bandwagon in India and the notion to make quick money, which led the mammoth growth of the company, this clears that the gigantic growth of the company in these little over 5 years was directly proportionate to the speedy growth of gambling and betting activities in India. The council submits that out of the games provided by the company, games like lottery are inherently games of chance, as been stated in various case laws and legislation. For the matter of fact, Section 5, subclause B of the Lotteries Regulation Act 1998 imposes prohibition on the sale of computerized or online lotteries which are sold via internet, as it works on a simple, quote-unquote, draw-by-chance metric, where the prize pool and the reward are solely based on luck. In games where both chance and skill involved, the council pleads that such a game has predominance of chance over skill, and this will be further explained in the forms of the issue.
In the game you said rummy game, for example, getting jokers or getting good cards may be a chance, but forming the sequence of 4 or 3, if the player decides that it's better to drop the game, he will drop, so that he will only land up in 20 points. So he can drop 5 plays and he will land up in only 100. So if he gets in the next game, if he gets good cards, he can continue to play. So there is discretion. At the end, whoever has the lowest points will be the winner and he will make money out of it. So how can you say it's a game of chance? There is discretion, there is decision.
Rummy involves both skill and chance, and the council does not argue it to be solely a game of chance, but predominantly a game of chance. This is because the council argues with rummy, which involves stake, which is played and won predominantly on the basis of chance. The involvement of luck over person's intellect to win this game is preponderantly more in the game of rummy, as it was held in the case of Digital Works Limited versus the state of Kerala, that online rummy is no different than physical rummy, as an online player may be dealt with ready-made hands and where clearly no skill is involved, and the luck of pick a card which a player needs for a set or a sequence may be discarded by the player above him.
But in case of horse racing, in the physical race, the person betting has no control over the jockey or the horse. But here in online, he himself will be the player, no?
No. The algorithm is horse racing and similarly of fantasy cricket is really ambiguous in this nature. As stated in the case of Maguranjithan Mandaram versus state of Tamil Nadu, held that whether a game is considered to be one of chance or of skill is a question of fact and needed to be considered on the fact circumstances of each case. And in our case, the algorithm which is provided by the company is really ambiguous. So the council argues that and it is not the form of traditional horse racing which has been provided as a game of skill in many statutes, but the online form of horse racing which runs on a very questionable format.
What do you mean by algorithm being ambiguous?
With the meaning of algorithm being ambiguous is there is no scope of skill being involved in it, and the company has laid down no framework. For example, the petitioner briefed the court with the algorithm using Fantasy League app, that is Dream 11, and that was held in the landmark case of Shri Varun Gambhir versus the Council State Commission for an extension. In the case of Varun Gambhir versus the state of Punjab and Haryana, in that case, the company Dream 11 laid down the whole format, the whole framework that how their game proceeds. There is no nature of ambiguity in the algorithm. But in our case, and also it was held in the case of Anchal versus state of Tripura, it was observed that the petitioner was alluring people in the name of higher return, saying that the game works on the basis of Dream 11.
Is the online rummy is different from the regular rummy that one plays in a club or on a table physically?
No.
What's the difference in the algorithm?
The algorithm, that is the sole difference is that there is the scope of ambiguity and a scope of cheat in the game.
How is it? Can you please explain?
Yeah, because the cards are the players are given handmade cards, ready-made hands in the starting of the game in online rummy. So as in our case, the petitioner have not laid down any framework of their fantasy league gaming, which makes it difficult to believe that it is simply parametered to Dream 11. Also keeping in mind that the result of these kind of game, as stated in the paragraph 3 of the very last line of the fact sheet, is based on gain for few and loss for many. So such kind of questionable format of gaming gives no space it to become a predominantly game of skill, but rather a game of chance.
You want to tax 75% of the collection. Under what HSN code you wish to tax them?
The second council will be, this question will be dealt in detail by my second council. And with these contentions, if the court, if this honorable bench just held that these games are a game of chance, considering the games offered by the company substantially of being game of chance, there is no doubt that these games should be taxed at 28% as per the GST rules. It was an honor appearing before this honorable bench. Thank you so much.
Questions to answer. You can complete that and proceed.
Certainly, Your Lordship. Your Lordship, the second question that was asked by Your Lordship towards the very end will be dealt with first with the issue third, which deals with whether the tax is payable on the entire consideration. Your Lordship, we submit. Sure, Your Lordship. Your Lordship, the fact sheet where it has been clearly mentioned that the company was earning around 5,000 crore rupees in a financial year or a fiscal year. Your Lordship, if we do very basic maths, we may find out that approximately they might have earned around 25,000 crore rupees over the course of 5 years. If they claim that they only keep 25% of this consideration, then at the end of 5 years, they will have 6,250 crore rupees approximately. At this point of time, it becomes imperative to note what is further said in the paragraph 6 itself. The company was going forward with issuing swanky leases for their offices. The company was going ahead with expensive, lavish expenses for their company. They were giving top. Sir. In a game of skill, they shall be taxed for their actionable claim. The exact HSN code for the same stands to be 999692. Your Lordship, we submit in front of the Honourable Court primarily that when this company goes ahead with expensive expenditures on offices, they provide top-tier salaries to the top-tier employees as well as mid-tier employees. At that point of time, it becomes a little confusing to the GST department as to how, by having only 6,250 crore rupees, over the course of 5 years, they are able to maintain all of these expenses since they've claimed that their only revenue stands to be from within 25% of the Your Lordship, we believe that that is something which shall be initiated, which can be initiated later on. However, at this point of time, our contention starts to be with regards to the fact that they're trying to defraud the GST department by claiming that only 25%.
Your logical reason was that they are swanky offices. There were a lot of employees, who are earning, large sums of money as salary. If that is so, that cannot be the basis on which the GST can be sought. It is only income tax department which can, find out whether they have suppressed the income.
So,
as far as GST is concerned, you are covered by the GST Act, and you have to follow only the GST Act and the rules.
certainly, Your Lordship. However, we
No
believe.
one goes the swanky offices, anything to do with the GST.
Certainly, Your Lordship. Your Lordship, we believe that they create. Certainly. Yes, sir. We believe that this is important and imperative to note since it creates a reasonable belief within the mind of the GST department that when they tell us that they have kept 75% of the amount to be an actionable claim which they keep in a separate escrow account as has been their claim, that becomes reasonable belief to doubt that. There exists an angle of
Find out, whether they have returned those 75% of the amount that they are kept in an escrow or not.
Your Lordship, the same cannot be done as per the clear mandate since the IBC has already been triggered and therefore the powers of the GST department and have been conferred to a certain extent.
IBC order was long after your attachment,
So,
long after your assessment, long after your investigation.
Certainly.
To say that your investigation got started
Your Lordship, with that point, we would like to mention that the show cause notices, when they were published and they were sent to the company, we believed that the company believed that the company shall provide us with clarifications as to why we should believe them, why their actionable.
That was the case, and trying to explain why for the initial years, notices were given under 74, and for the later years, only under 75.
Your Lordship, we believe that initially first.
Banking officers were released for the last 4 years, and next 2 years they moved into some kind of an old unswanky.
Certainly not, Your Lordship. However, we believe that once we had decided that the company did in fact commit fraud, the same can be conferred from the very first year for which Section 74 was utilized to issue the notices. We believe from there on forward, we did not wish to increase the tax liability, since the penal interest will also increase the tax liability of penal interest from 10% to 28% under Section 74, and therefore make the repayment of these taxes completely intelligible, even considering the current considerations.
So you chose to ignore statutory obligations because of reasons such as exigencies in recovering. Is that one question?
Certainly not, Your Lordship. We apologize if that was if it was coming out like that. What we meant instead was that once we have clarified that this company committed fraud, from beyond there, this company did not realize, and at that point of time, there are certain cases which have been brought in, and on the basis of which.
We invoked 74 for the first case because you are conscious you have to save the nation. For the next 7 years, you do not invoke 74. You only invoke 74. Therefore, there is a very fundamental issue.
Your Lordship, we deny that. We believe we submit in front of the Honorable Court that the reason why only first year was considered to be committing a fraud, whereas the other years were considered to be erroneous mistakes, is because firstly.
Explain what is that? What made you think so?
Yes, sir. Yes, Your Lordship. Your Lordship, we believe that firstly, once the committee had committed a fraud, in the years which came by forward, there were certain judgments which had came in, and the basis of which, as per that amount of time, relying upon the said judgments, it could be considered that the company was in fact mistaken. However, in the very first fiscal year, no such judgments were at the liberty for the company to consider and therefore decide that it shall in fact not pay the consideration, the tax on the entire consideration, and at the rate of 28%. One such judgment that we believe stands to be the Sunrise Associates versus the NCT of Delhi, which is published, on the basis of which we do realize that certain companies might have thought that lottery can be exempted from actionable claim. However, we shall be submitting within this issue why that is not the case.
But you said it's 75% will not be entirely dispersed, treated as actionable claim. Therefore, 74. Undercutting that argument by the state.
Definitely not, Your Lordship. We believe that that stands to be one of the reasons on which we shall furtherly be elaborating within the issue 4 as well. Certainly, Your Lordship. Your Lordship, we believe that while this stands to be the first argument that we submit to you, on the basis of which this actionable claim, the GST department does have a reasonable doubt that the company did in fact tap into for utilizing their own revenues. Otherwise, there is no way they would have had 6,000 crore rupees left even after 5 years when they had earned only 6,250 crore rupees. Moreover, we believe, secondly, that when we talk about an actionable claim in this particular consideration, the definition that they mention has derived its jurisprudence from the from the Transfer of Property Act 1930, which in and of itself has taken the definition from the English law jurisprudence. Your Lordship, the English law jurisprudence with regards to actionable claim is extremely clear. They mention that anything which is chosen possession does not stand to be an actionable claim, whereas anything which is chosen in action stands to be an actionable claim. While we realize that for a participant who is participating in a game, at that point of time, the amount or the prize pool money can be an actionable claim, the company at all points of time takes the entire consideration themselves from the participants and then takes the active agency to bifurcate them. At all points of time, the escrow accounts are maintained by the company. At all point of time, the company is in fact in possession of those particular assets as well as that monetary value. Therefore, they cannot claim that for the company.
What we understand from the facts that are given is each participant has to make 2 kinds of payments. One is arbitration and another is fee. So the participant makes 2
Certainly, Your Lordship. However, at the end of the day, it is the company, it is in fact the company that keeps the accounts for both of these payments. It is the company that decides the amounts for both of these payments. It is the company that provides the services on which these payments are made. The company acts as a provider, not as an intermediary. The company does have the assertion as well as the algorithm to determine which player wins, what is the reason for the winning. Moreover, and most importantly, Your Lordship, even if we assume for a second and accept even if we assume for a second but not accept that the company does in fact run games of skills. Even at that point of time, Your Lordship, the providing of the prize pool money to the players becomes an intangible marketing strategy for the company. The reason this company is able to gain so much prominence within their services is because they provide this particular marketing strategy. Your Lordship, we are not the income tax department. We are the GST department.
Does not the statement itself, India in itself, that the full money is paid to the funders?
Pardon?
The statement that you make, that the strategy of the company is that you pay that full money to the funders or the persons who play the online game, and therefore it incentivizes them to come and play.
Certainly.
That inherits in itself that that amount of 75% which they have kept in escrow is given back to them.
Your Lordship, when we mentioned or submitted our first argument, we did not mean to say that the company does not disburse any amount. We meant to say that the company does not disburse the entire 75% that they have kept in that consideration. Since then, it would become difficult to believe that without tapping into that consideration, they would have 6,000 crore rupees left, when as per their claims, they would have only earned 6,250 crores within 5 years. Your Lordship, we believe that the company does provide certain money. Yes.
So you are accusing the company of keeping certain amounts in the escrow, right?
Certainly, Your Lordship.
Was that a part of your show cause notice or the order? And or the accusation was there?
Your Lordship, when we mentioned that they shall be taxable on the actionable
I'm
claim.
talking about the show cause notice, whether there was an accusation that the entire 75% of the pool money was not distributed among the punters.
Your Lordship, we had made it very clear that we do not consider this actionable claim.
Sorry, it's still not getting my point, because you are accusing the petitioners of keeping the pool money, the 75% of the pool money. A portion of the entire pool money is not being distributed. Right? Am I understanding you correctly?
Certainly, Your Lordship.
If that is the case of the department, then was there an accusation in the show cause notice? Or was there a point, did they make a point that this point was made in the show cause notice? Was it made? Or in the order?
Your Lordship, we believe that when we clarify that we do not consider this actionable claim and on the basis of which we do wish to tax the entire consideration, we believe that it was not that imperative to explicitly state as to what are the reasons why we do not believe that the entire consideration should not be taxable in this case. The GST department.
So slightly digressing, it does not assume that they are not dispersing the actionable claim. It's assumed it is being dispersed.
Surely, Your Lordship.
To the point of law, that if the 75% they temporarily possess it, you mean to say GST is to be applied even on that, even if somebody temporarily possesses that owning amount?
Certainly, Your Lordship. We wish to transfer to that argument ourselves. So at this point of time, let us assume that the company did in fact disburse all of that amount. Even then, Your Lordship, firstly, a prima facie, as we mentioned, the Rule 31A of the CGST Act being applicable, the company should have paid the taxation on the actionable claim as well, since the actionable claims are in fact taxable in cases of betting and gambling. Moreover, Your Lordship, when we mentioned that without this actionable claim, this company's services will not exist in the prominence matter that they do currently. What we mean to say is the GST department is not here to tax them on the revenue that they collect, but rather on the services that they provide. And for those services, this actionable claim stands to be an inherent part without which the services would most likely not seem to exist in the manner that they currently do. This stands to be a marketing strategy for the company on the basis of which their services work, on the basis of which their services go beyond a particular level. Therefore, we believe that regardless of whether this court shall decide whether these games are games of skill or games of chance, at the end of the day, these games cannot operate at the level that they do. These games cannot earn the money that they do without the consideration of the actionable claim being present in front of the player. We realize also that the jeopardy of double taxation does not arise here, since the one tax that is being paid by the players is the income tax, which is a direct tax, whereas the GST department's tax stands to be an indirect tax, and therefore the jeopardy of double taxation is not applicable in this case.
Coming back to the first question, which you have not yet answered. Okay. The petitioner has classified the total consideration into 25%, which is taxable at 18%. Rest of the 75%, he has classified it as taxable at 0%. So there is classification. And when that is there, how can you prove that they have suppressed the fact, they have an intention to evade tax, or there is willful misstatement? Nothing of such. Could you please explain how can you invoke penalty provisions?
Certainly, Your Lordship, we believe that your timing could not have been better, since we were about to ask for permission to proceed to issue 4 if there are no further clarifications, where we shall be dealing with that question.
Yes, last time the question to you, and now you are again.
No, certainly not, Your Lordship. I'll make it certain that it is the first thing we do.
I'm glad you answered.
Your Lordship, when we talk about the fact that whether the GST department shall be treated as a secured creditor in this case or not, before we move on to the obvious Rainbow Papers Limited judgment in this case, which the petitioners have already somehow preempted, is something we're going to bring up. We would also like to state that the company has in fact committed fraud in this case. The reason we mention so, Your Lordship, is because when the company goes ahead to say that all of its games are games of skills and claims that none of its games are games of chance, at the same time keeping in mind the fact that this company had the best legal and accounting team in the country, as they have claimed, and so has been mentioned in the Moot proposition and the fact sheet, at that point of time, Your Lordship, it becomes difficult to understand as to how this best legal and accounting team will somehow not be aware of the fact that lottery, the games as inherent as lottery, stand to be a game of chance in the nation of India. And the company will not, and the best legal team will not be aware of the fact that lottery, the tax shall be paid on the entire consideration. Moreover, Your Lordship, when we mention the reasonable doubt that we had talked about in the previous issue, that also goes on to show as to how this company had malified intentions in order to make sure that they can get away with the code. Moreover, Your Lordship, we believe that the company was given sufficient time to respond to the show cause notices and to tell us as to how and why the GST department shall not issue these orders or shall not initiate recovery on these orders. But they did not do so, but rather wait their entire time and wait out the time periods and the stipulated time in the statutory code of the CGST Act. And rather, when the insolvency and bankruptcy code was triggered, at that point of time, since the IBC had been enacted and the IBC stands to be an exhaustive law where Section 238 is applicable.
Do you have any specific case laws or rulings to show that this is a game of chance? Because they were able to demonstrate by each game, with poker, horse racing, and lottery, to show that it's a game of skill. Likewise, do we have any case laws to show that courts previously holding that this is a game of chance rather than a game of skill?
Certainly, Your Lordship, we believe that a Dream League fantasy gaming had been held as a game of chance in the case of Anchal versus State of Tripura, as was submitted, where a game of SF11 was being run, which was ran in the name of Dream 11 Company. However, it did not follow the same algorithm on the basis of which it was in fact committing fraud. Moreover, Your Lordship, we believe that there are other cases which is provided by my previous counsel on the grounds of which there does exist a reasonable doubt within the current forum that whether these games are games of chance or games of skill. On this contention, we also submit in front of the Honorable Court, Your Lordship, that in the lieu of technology, these companies such as these are able to make sure to get away with any tax liability by simply stating that their games are games of skill. However, at that point of time, it becomes difficult to understand as to how people will simply, on the basis of game of skill, participate into this game so much, especially when it is directly proportional to the growth of gambling and betting in India, as multiple reports have indicated as well. Your Lordship, it is also imperative to understand that under this veil of technology, we grant these companies extreme permission and extreme accessibility to simply defy the natural justice of taxation within the country. We fail to realize that this GST department does not tax them for no reason whatsoever. We tax them because they have been running a company of services within the nation of the country. And on the basis of the very set arguments, we believe that frauding such central government agency is not something that we should get away with in lieu of technology by simply stating that their algorithms do in fact somehow always magically seem to be games of skill, even though players are in fact losing more than they're winning. Moreover, players at the end of the day, all of these companies being games of skill are still earning such amounts. Whereas if the Dream 11 was such a skill-based game and the rest of the games were also skill-based, there should be disproportionate amount of income that the companies were earning. And a company which was running a very similar skill-based game to Dream 11.
Are you satisfied with that? Because they offer lottery is one of the options. The other options like running, poker, and all of them must be picked at the same or the game of chance.
Certainly not, Your Lordship. We mentioned a case ruling for fantasy gaming as well. We also mentioned. Your Lordship, with regards to rummy and poker, we must realize that the major element of these games being games of skill, considered as game of skill in certain cases, is due to the nature of the fact that there are certain soft skills, as multiple people say, are involved in these games as well. However, in online gaming and an online setting environment, the particular person is not able to exercise his ability to hold, raise, so on and so forth, up to the extent that the game of skill comes out in an online format. And moreover, the algorithm.
In a game of rummy, as against a game of rummy format. Not to be very clever, not to that extent.
We should elaborate on that argument then, Your Lordship. Moreover, in an online environment, the algorithm can be predetermined by the particular company on the basis of which they can easily manipulate the players and the cards which have been shuffled. At least in an offline environment, we do know for a fact that these cards have been shuffled on random. However, in the online environment, they're predetermined, and therefore we do not know if this element of randomness is there or not.
That is your belief, that is your presumption. But you do not know the software. They do not have a control over the software.
And moreover, you are accepting that game of rummy is a game of skill if it is played at table.
So, no, Your Lordship. All that we are.
That's what you suggested. You are in fact trying to suggest.
Your Lordship, when we mentioned that with regards to the fact that there have been certain judgments which have held game of rummy to be a game of skill. However, that has primarily been done for the offline game of rummy, not primarily for the online game of rummy. Moreover, Your Lordship, we believe that whether these games are games of chance or skill is better left to the opinion and the verdict of the judges. However, we will further wish to move ahead with the rest of our arguments.
Before you move ahead, just I want to know whether the department is going ahead with the section 78 in all the cases where orders are passed.
Your Lordship,
They are invoking section 78 in all the cases because I have to believe hundreds of orders are passed. Are they going ahead and invoking section 78 in every case?
we shall substantiate on that issue, Your Lordship. We believe that Section 78 needed to be invoked as has been stated when there is an imminent danger or expedient danger to the taxation revenue being collected by the company. In this case, the same was observed due to the NCLT order being passed. At that point of time, the financial creditors such as NBI would have absorbed 5,000 crore rupees from the company altogether, which would already reduce the assets which are currently not enough in the present case itself to repay the GST department, and therefore
That is one of the reasons arguments to say your orders under section 73 and 74(9) are arbitrary. We have concluded the hearing on 30th of September, came up with order on 3rd of October. Because you anticipated this, we have not considered all factors. So those were all orders made in haste, therefore, after that's what the arguments were.
Your Lordship, we would like to clarify on that issue that firstly, when we talk about this particular case, our show cause notices were primarily issued much before the insolvency. Moreover, when we talk about the company's recovery process being initiated, it was initiated at 10 a.m. However, as soon as at 10:30 a.m., the moratorium was declared, the company, upon hearing the public announcement, did file as a secured creditor, which goes to show that the company did not simply resume with its recovery procedures, and therefore, at the end of the day, did try to be in compliance with the ABC laws. The reason we believe that we submit that this is important is because, Lordship, we request for an extension. Your Lordship, the reason we believe that this is important is because when we discuss the applicability of the Rainbow Papers Limited judgment, we realize that the permissive laws under Section 82 of the CGST Act has been mentioned time and time again. However, we believe that this permissive laws only and only gets triggered when anything otherwise to the IBC happens. However, that is not the contention that we make here, but rather a contention of harmonious construction between the IBC law and the CGST law. Your Lordship, it is imperative to realize that even within the judgment of Rainbow Papers Limited, since we realized that the GVAT Act did not have a specific provision laws. However, if the GVAT Act had been inconsistent with the IBC law, under Section 238 of the IBC law in and of itself, it would have been held that the Section 48 of the GVAT Act shall not be allowed and the Gujarat State Tax Department shall not be allowed to be a secured creditor. Therefore, even in that judgment, Honorable Justice Indira Banerjee did deliver that judgment on grounds of harmonious construction, which can be achieved interpreting the definition of secured debt to also include that of security interests which have been created by legislation and statutory authorities. Your Lordship,
only to make use of this judgment, your attachment was in a hurry, can we say that?
certainly not, Your Lordship. We believe
Then why would there be a hurry? It seems to be non-application of mind with regard to attachment. You gave a patient hearing, but the attachment happens in the visitor. So is it only to be able to do that? Can it be inferred only to make use of that Rainbow Papers judgment and to claim yourself as a secure creditor to hurriedly, even before waiting for the order, without any discipline towards a judicial forum, you made the attachment?
certainly not, Your Lordship. At that point of time, it was not confirmed whether the company shall be declared insolvent or not. At that point of time, the moratorium had still had to be passed. The case had just been accepted. The GST department did not know for a fact whether the company will be declared insolvent or not. Moreover, not only that, it is also imperative to take in consideration the fact that the GST department at all points of time, once the IBC law has been initiated, did try to comply with the same. Moreover, when we gave them the time for patient hearing, we request for an instruction. When we gave them time for patient hearing on multiple accounts and they did not respond to the GST department at any point of time, we believe that at that point of time it became rather stagnant as a course of interaction between the company and the GST department. At that point of time, we realized that in case the company goes insolvent or in case the company does not go insolvent, regardless of that, the GST department has in fact given them enough time, and NBI, being a bank, will in fact also start its own proceedings to try and recover the amount that is due to it when it realizes that the company might or might not be able to pay it. At that point, the importance of experience of nature of revenue collection does in fact become important to the GST department. Moreover, Your Lordship, another contention that we argue with regards to the GST department being treated as a secured creditor is not just on the applicability of the Rainbow Papers Limited judgment case. However, another thing that we would like to take out from the ground is a case of Imperial Chit Funds judgment in which it was held that when the income tax department has certain vicarious liability under Section 178 and Section 179 of the Income Tax Act, due to there being penal interest, then at that point of time it is important that the income tax department shall be held with regards at the same level as the secured creditors at the time of binding out. The reason we believe that this is important is because once there are penal interests which the company has not paid, it is imperative that the company in one way or the other has tried to fraud or has tried to commit evasion or has erred in providing the GST department and the tax department, in providing the tax departments with the money that they are in fact owed and should be provided to them. We believe that we submit that the Section 88 of the CGST Act stands to be parameteria to the Section 178 of the IDC Act. Moreover, the Imperial Chit Funds judgment was also a judgment that was firstly initiated by a single judge. Your Lordship, we request for just 1 minute. Much obliged, Your Lordship. And the Imperial Chit Funds judgment also initiated firstly as a single judge judgment, however further transgressed into being upheld by a full bench of the High Court and then by the Supreme Court. Your Lordship, we believe that within this Section 88 there is no proviso clause as well. We would also like to reiterate the fact that regardless of whether there is a Section 238 of the IBC, that will only and only be triggered when there is a contradiction with regards to it, with regards to the IBC. At all points of time, we have tried to work within the compliance of insolvency and bankruptcy code. Therefore, not only on one but two grounds, considering the fact that the GST department does not trigger the proviso clause, since we do not go against the IBC mandate but rather work within the IBC mandate, we believe that harmonious construction shall and can be achieved in this case, and on the basis of that, the GST department's right to be treated as a secured creditor shall not be taken away, as these companies will continue to defraud the government and at the end of the day simply get away with it, and the owners, due to the clean slate approach, can simply wipe off their liabilities and then go ahead to create another company. We would like to read. Wherefore, may it please the Honorable High Court of Karnataka, in view of the facts and circumstances narrated, issues raised, arguments advanced, and authorities cited herein above, the defendant most respectfully prays that this Honorable Court may be pleased to declare the petition as not maintainable in front of the High Court, declare the games by the company as games of chance, declare that the tax is payable on the entire consideration and the applicability of actionable claim is not present in this case. And lastly, declare that the GST department shall be treated as a secured creditor in light of the very facts of this case. And or pass any order, direction or relief that it may deem fit in the best interests of justice, equity and good conscience. Rest is left to this Honorable Court's wisdom and fine sense of judgment. With that, the respondents rest at peace.
May I clarify how much time do I have? 5 minutes. Thank you.
What are the points that propose to clarify?
Indeed, Your Lordships. Your Lordships, beginning with the fact that the Learned Counsel for Respondents have challenged maintainability based on 3 different submissions. The first submission of theirs is that we can approach an appellate tribunal under section 107 of the CGST Act. Your Lordships, the appellate tribunal has still not been constituted yet, and the same is evident by the recent finance bill number 17 of 2023, wherein Lok Sabha is now at this present moment directing states to create appellate authorities right now, which is why the petitioner company could not avail that remedy. Moreover, Your Lordships, when they say that the jurisdiction of NCLT could be invoked in the present case, Your Lordships, in case the jurisdiction of NCLT would have been invoked in the present case, NCLT is not competent to deal with the demand orders and all the orders passed under section 73, 74, 78, 79 of the CGST Act. And the same would not be dealt by NCLT because the provisions that the Learned Counsel for Respondents rely on for NCLT's jurisdictions are, in and of itself, those very provisions restrict the jurisdiction of IBC for operation of under Companies Act or the Insolvency and Bankruptcy. Your Lordships, lastly, it is contended by petitioners that since there was a question of law and interpretation required in this case and violation of principle of natural justice, maintainability is maintained on the side of petitioners. Moreover, Your Lordships, in their last contention where they say that moratorium can oust the jurisdiction of High Court, it is humbly submitted before this Honorable Court that the jurisdiction of the writ jurisdiction of the Honorable High Court cannot be ousted by merely by any statutory code like IBC or any statutory proceeding like moratorium, and the same was held in the Honorable Supreme Court's judgment of Embassy Property Developments versus State of Karnataka. Moving on, Your Lordships, it is also pertinent to note that the judgment that the Learned Counsel of Respondents relied on for classifying online rummy as a game of chance is erroneous. Your Lordships, the judgment of Head Digital Works Private Limited versus State of Karnataka does not say that online rummy is a game of chance. On the contrary, it says that online game of rummy is a game of skill and it falls within the side of petitioners. What the Learned Counsel of Respondents argued was the argument that the respondents in that particular case made, and it is not the ratio which the actual court decided in the end. Moreover, we also rely on the case of the Narayan case, which is the case of Supreme Court, to hold that rummy requires the exercise of skill. Moreover, Your Lordships, moving forward with the other game contentions that they've defended on different games. First,
last sentence of the Satyanarayan.
Your Lordships?
Last sentence of Satyanarayan.
Your Lordships, the council doesn't recall the last sentence
It
exactly.
says that under certain set of circumstances, it could be a game of chance, even running.
Indeed, Your Lordships. However, in the present case, as we have, as the company has mentioned, the rummy played on its platform is a game of skill because there is predominance of skill in the first place. Since it's not an informal setting of rummy played between players, it is a formal setting by a company which seeks to earn money, which seeks to attract players. They have to create a platform wherein skillful players attend their platform, earn money, and also increase the revenue of the
Now,
company.
what happens in case an unskilled person, like me,
Indeed, Your
person plays against you for an expert?
Your Lordships, in case Your Lordship is an unskilled player and goes against me if I'm a skilled player, then Your Lordships have a predominant chance of losing the game because the exercise of skill would prevail. No, Your Lordships, a skillful player would prevail. Much obliged. Your Lordships, in terms of other games, in terms of online horse racing, they contend that it is different from actual horse racing. Your Lordships, the paradigm has been shifted and online information is provided in abundance right now. That information gives information to the online player about the breeder, the company of the breeder, the brand of that company, the brand of the jockey, and what the past practices of that breeder and jockey has been. And based on those statistics, a calculated decision can be made, as is made in offline horse racing as well, and the exercise of skill is upkept. Lastly, Your Lordship, the Council for Petitioners would like to mention that the reliance on the fantasy cricket judgment goes against multiple High Court judgments. The single bench judgment relied on by respondents was overturned by a divisional bench judgment in Chandresh Sankla versus State of Rajasthan. Moreover, Your Lordships, an extension of 2 minutes. Moreover, Your Lordships, in the judgments of Varun Gambar, Gurdeep Singh Sachar, all these judgments of Honorable High Courts say that fantasy cricket, especially Dream 11, is a game of skill. The reason, Your Lordships, are that the player online needs to assess things like pitch compatibility of the player that you are placing in priority, team coordination, the form of the current player, and the priority of players that you create within the act. Your Lordships, the Council for Respondents also argue the petitioner company for defrauding, accusing the company of keeping their money. Your Lordships, it is nowhere mentioned in the fact sheet that said that the company is keeping the actionable claim to themselves. It's a fictitious assumption created by the respondent company, wherein they say that actionable claim was retained by the company. Your Lordships, let us assume, in case the company keeps the actionable claim to themselves, the participants who are expecting that actionable claim as a prize would be agitated and would not participate in the company further, which is why there is no way that the actionable claim of the pooling fee could have been retained by the company in the first place. Your Lordship, moreover, when they cite that harmonious construction can be achieved in the present case, it cannot happen because it disturbs the charge created by CGST Act disturbs the priority under IBC. Moreover, it contradicts the orders of Supreme Court in judgments like Sundaresh Bhatt versus CBIT, where it was held that for a paramateria provision which creates exception for IBC, the department would not become a secured creditor. Hence, the Council for Petitioners contend that we cannot go against the Honorable Supreme Court's ratio which has been laid down. Lastly, Your Lordship, when they say that online games cannot exercise soft skills, it is submitted that soft skills can be exercised in online game as well. I can make pauses while I make bets so that others anticipate my behavior. I can make large bets to show to the other players that I am bluffing. I can make smaller bets and concede in the other rounds, etc., etc. All of this means that I can create soft skills in online game as well. To conclude, Your Lordships, it is submitted that the reliance on multiple judgments of the Council of Respondents is erroneous, and prayed that the Honourable Bench may be pleased to judge and declare in the favour of the Councils for Petitioners. Much obliged. It was an honour arguing before this bench.
We wish they would have done this much interaction with us with regards to the show cause notices, Your Lordship. Your Lordship, replying to the rebuttals that have been raised by them, we have actually reserved 4 minutes for this. Your Lordship, replying to the rebuttals that have been made by the petitioner in this case, firstly when they mentioned that multiple judgments have held that fantasy league gaming stands to be a game of skill, all of them have held the same with regards to dream level. The entire contingency on which we based our arguments was that all of these games are supposed to be treated differently on the basis of the very merits and facts of these games. The judgment of Manoranjan Mandram versus State of Tamil Nadu clearly dictated that in determining whether a game is a game of skill or a game of chance, it must be held at its own value and its own interpretation rather than a hasty generalization as well as a stereotype. On the grounds of that we mentioned and requested and multiple times requested through the show cause notices if the company could provide to us as to what metrics their game works on, and they did have a reasonable time to prove that their metrics of the game are in fact a game of skill, and they could have mentioned the same to us, under which time they could have proved that their game stands to be a game of skill. However, the fact that they did not wish to do so is another willful misrepresentation. Your Lordship, we believe, we submit to the Honourable Court that when the company waits for the case to go insolvent, after which deciding whether these games were played in the exact manner that they submit in front of the Honourable Court becomes extremely difficult since the company is not running anymore and the games are not being played anymore. At that point of time, the company's magnified intentions can be seen to some extent, since if they had belief in their games, then they could have provided at the notice of the show cause notices itself how their game works, and on the basis of which they could have shown us why these games shall be considered as games of skill and not as games of chance. Your Lordship, we also submit to the Honourable Bench that fraud has been committed in this case. For this, I had substantiated reasons as to why. Certainly, Your Lordship. Certainly, Your Lordship. The reason we mention this is because when they come up ahead and state the Sundaresh Bhatt case and therefore recite that currently the Honourable High Court of Karnataka cannot supersede that judgment and cannot reverse that judgment, we state that in this case the GST department can not only be considered as a secured creditor as per the applicability of the Rainbow Papers Limited judgment, considering the section 48 of the GVAT Act to be pari materia, but also on grounds of the Imperial Chit Funds judgment that we had submitted in front of the Honourable High Court, on which there has no such ruling been issued by the Supreme Court. And therefore, if the GST department shall have its right as a secured creditor, there is not just one but a different way to achieve that as well. Moreover, we believe that at the end of the day, the verdict shall be decided on the basis of merits of the case and not just because a different ruling had been passed in a higher court. Since we also submit that over here as well, there is a bench of 5 judges, and at the end of the day, if one course of remedy cannot be chosen just because of a restriction of an upper court judgment, then at the same time, we provide a different course as to which can be availed to treat the GST department as a secured creditor, similarly to how the ITC department has been treated as a secured creditor when there have been penal as well as interest rate dues. The reason it is important is because the section 88 of the CGST Act, as we submitted, was pari materia to section 178 of the Income Tax Department Act, which was the reasoning for the ratio decidental given in the said judgment. If there are no further clarifications, we rest. Thank you so much.
I welcome you to the valedictory ceremony of the 20th Surana and Surana National Corporate Moot Competition and Judgment Writing Competition 2023, hosted by Surana and Surana International Attorneys and JSS Law College. Seeking the blessings of His Holiness Jagadguru Sri Shivradreshwara Deshakendra Mahaswami Pilavuru, let's commence this valedictory ceremony by invoking the blessings of Almighty. I'd like to call upon Ms. Vismaya for the invocation.
जय देव श्री गणपति राया जयकारक भयहारक ओंकारकाया जय देव श्री गणपति राया जयकारक भयहारक ओंकारकाया जगदम्बೆಯ ಮೈಮಣ್ಣಲಿ ಮೂಡಿದ ಮೂರುತಿಯೇ ಮೃಗಧರ ನೋಡಿದ ಮಾಡಿದ ಬೇರೆಯ ಆಕೃತಿಯೇ ಚಿಗುರಾಯಿತು ಎನ್ನಾಲಿಗೆ ದಿನ ದಿನ ಶ್ರುತಿಯೇ ಹಗುರಾಯಿತು ನಿನ್ನೆನಪೆ ಸುಳ್ಳಾಯಿತು ಮೃತಿಯೇ ಜಯ ದೇವ ಶ್ರೀ ಗಣಪತಿ ರಾಯ ಜಯಕಾರಕ ಭಯಹಾರಕ ಓಂಕಾರಕಾಯ ಓಂಕಾರಕಾಯ ಓಂಕಾರಕಾಯ. Thank you.
Thank you, Ms. Maya. That was indeed divine. Now I'd like to call upon Professor K. Suresh, Chief Executive, JSS Law College, to welcome the gathering and the dignitaries on the line.
Very good evening, Honorable Justice and Venerable guests on the dais, invitees, judges who judge the 20th Corporate Moot Competition, participants, dear students, ladies and gentlemen. It is indeed an honor for us to host this prestigious Moot Competition. We've been hosting it actually since 2009, and now we have reached this last lap of this competition, 2 days competition, and we are all eagerly awaiting not only the results of hard-fought battle of wits and also some valuable inputs by the judges and the chief guest. For this valedictory function, we are fortunate to have with us Honorable Judge, High Court of Karnataka, Honorable Justice Bhutanusur Mallikarjun Shyam Prasad. Justice Shyam Prasad did his BA LLB degree from Bangalore University and started his law practice, and he became an independent practitioner in 1997. And after having worked under a few senior advocates, he was designated a senior advocate in 2014 and was appointed as additional judge of High Court of Karnataka, and he became a permanent judge in 2020. Temperamentally equipoised and ethically overreaching, Justice Shyam Prasad is a man loved by all. It's our great honor to have him with us this evening for this valedictory function. I extend him a very warm welcome on behalf of everybody present here. The president of this function is none other than the Pitamaha of legal profession, Sri Uday Valla, who has just completed 50 years of his practice this year in Bangalore. Celebrated advocate, and he is a pride of Karnataka. He was born in 1951, did his bachelor and master's in law in Bangalore University, and enrolled as an advocate in 1963, established his firm Holla & Holla in Bangalore, and specialized in corporate law. Literally every branch of law actually has been actually his forte. And to quote a few, he is into corporate laws, mergers and acquisitions, foreign collaborations, joint ventures, monopolies and restricted trade practices, foreign exchange regulations, trademarks, patent, copyright laws, banking laws, property laws, and whatnot, everything. And he has traveled extensively and also has received several awards, and he was an Advocate General of Karnataka for 4 times. That itself actually goes to show that his caliber, and as I already mentioned, he has completed 50 years of his practice. It's a great honor to have him today. He not only judged the finals, but also he is with us as president of this function. I extend him a very warm welcome. The guest of honor is YCS Swami, Appeals Commissioner, GST Mysore. when we requested him to be the judge of the finals, he already agreed and is with us. He was born in Tumkur, Karnataka, and has been in service across India in various postings in major cities like Mumbai, Delhi, and has served in intelligence agencies, Government of India, and Customs and Excise Department as well. So I extend him a very warm welcome. And Surana, needless to say how important and how valuable to us he is, and he has been actually cooperating with us actually in holding this successful competition. He has been with us for the past 2-3 years, spending actually plenty of time, and to be, yesterday he did not even actually have his lunch because he was so much involved in this work. Somehow actually had to force him to eat, right? So thank you, sir, for being with us, and I welcome him on behalf of everyone. And also my principal, Dr. Nataraj, who is here, has been helping us in actually organizing this. And most importantly, all the participating teams. In fact, in the initial stage, we received nearly 30 nominations, but some 5 backed out. And now we could actually have 25, and all important law schools of the country are being represented here. I extend all of them a hearty welcome to this Valedictory. And most importantly here, I must actually make a mention of our former student and advocate Karthik, who's here with us, and he's the one who has been actually drafting this problem right from day one when he started actually in 2001. I don't know how many more problems he has got actually in his head, and he has to draft actually many more problems for us in the coming days, right? I welcome him to this function. Welcome Karthik. And all those judges who have been with us the last actually 2 days to judge various actually rounds, I welcome all of them, and also our invitees and the press. One more last thing I cannot simply forget. Nagendra, my colleague, the coordinator, and his wonderful actually team of volunteers, who without them actually would not have been actually possible for us to successfully conduct this program. I welcome all of them to this valediction. Once again, I welcome all of you. Thank you very much.
Thank you, sir. On behalf of JSSLC, Surana and Surana, I'd like to welcome Professor K. Suresh, who is the backbone and a strength of pillar for all of us to the Valedictory ceremony. Welcome, sir. We heartily believe that at the core of the competition are the participants who compete in it. So I'd like to call upon any volunteers among the participants to come and share a few words. Do we have anyone? Yes.
Very good evening to everybody. Myself, Ilima Fatima from Lloyd School of Law. It was a great experience, to be very honest. I got to learn a lot of things, being prepared for almost 1 month or 5 weeks, I guess, and it was an honor. Despite of the results, it was an honor to be before Honorable Justice and so many special dignitaries. To be very honest, I'm really not interested in the field of litigation. I really want to pursue my career into judiciary or into ADR, but this particular moot, this is my and my team's very first moot, and this built a lot of interest in corporate law, especially the moot proposition, how balanced that moot proposition was. I mean, till the end, till yesterday, we were finding so many new contentions into it, so many new arguments to deal with. We were really amazed, and so such an amazing moot proposition it was. We were really mesmerized by it, and I would like to thank all of the dignitaries, all of the participants, to bearing with our team, to bearing with me, to hearing our arguments. And I would also like to thank both of my teammates, Rishita and Adit, to bearing with me, and you should also thank me to bearing with you, both of you. Amazing experience. It's only been 8 months into law school, and I'm getting to learn so much, getting so much exposure, interacting with seniors, interacting with so many seniors. This particular moot I'm going to remember through my life. Such a prestigious moot this was my very first moot, and doing such a prestigious moot, the 20th edition of Surana in Surana. I'm literally, as soon as I'm going to my place, I'm going to I'll be sharing the stories of it to everybody, to my faculty, to my batchmates, to my seniors, and in the coming years, as I step into second year, next year, to my juniors as well. Thank you very much. Thank you so much. Thank you.
Thank you, Lima. Now since the rounds have been over and the scores have been marked, I'd like to bring to the attention of the judges that Team CL7 is completely comprised of first years, if I'm not wrong, right? So first two teams are ready to the finals. We have career volunteers. Feel free to speak a couple of words about your experience during the competition.
Good evening, sirs. Good evening, everybody. We are from Christ University, Bangalore. I'm pretty sure she covered everything about how well the competition was, but she missed on one thing. We loved the management. We did not expect them to be as sweet and as hospitable as they were, and everything from the beginning or before we arrived here, everything about them was just, it was an experience in itself. We felt like we were at home, away from home. And that's one thing that I think is extremely commendable. And I would like to thank the entire management for having us here and for actually making us feel very special. And this entire experience and to be a part of this Moot is something I think all of us will never ever forget. That's about it. Thank you so much.
Thank you, Utsa. Now I believe we have time to squeeze in one more representative. Any volunteer participants? We need to represent our gender.
The respected dignitaries and everyone present over here. I'm Himani Baid and I'm from Amity University, Chhattisgarh. So everything is almost completed. Just one more thing is that we loved the accommodation, the vibe there, the whole feel. It was very special. And the life experiences which I learned during the whole Moot journey were precious to me. Right from how a team works to how can you become self-dependent, how do you manage time, all the life skills, all the love, all the support I've received from different persons on various steps. I really adore that. Thank you so much for organizing this and thank you so much. Thank you.
Thank you, Himani. It was indeed a pleasure hosting all the teams present here. Now I'd like to call upon Honorable Mr. Justice B.M. Shyam Prasad to address the gathering.
Shri Uday Holla, Senior Advocate, former Advocate General of Karnataka, Professor K.S. Suresh, Chief Executive, JSS Law College, Mysore, Shri Preetam Surana, Advocate and Head Academic Initiatives, SSI HNI, Dr. S. Nataraj, Principal, JSS Law College. My dear young friends, ladies and gentlemen. The first participant who came here and spoke really surprised us when she said she is just 8 months into profession. 8 months into law study. Congratulations, and that's wonderful. I come to occasions like this, what stands out is, and that is very infectious, what stands out is enthusiasm. Now if I can see this kind of enthusiasm in the first year, and if Madam keeps it going this way, I can imagine the kind of enthusiasm that would be there 5 years down the line. One comment, of course, and that would be a comment that would be on behalf of everybody on the dais. Where are the boys? We don't see boys putting their hands up. It was a wonderful display of preparation. All the 4 participants that we saw and their team, with sheets being passed over for filling questions. It could not have been possible without hard work. Preparation means hard work, and Madam said it was over a 5 weeks or a month, and that's a lot of time. So I congratulate all of you for that kind of effort. And 2 thoughts on the occasion from my side. You're all in colleges where you have the guidance of your teachers, you have the guidance of the curriculum that is designed painstakingly with a lot of thought, and your goals. Madam said she was looking, she's keen on judiciary. Hope that keenness continues and she joins me on this side sometime. Now, all these will keep you motivated, will keep you focused. My question is, and I would want this question to hang in the air for as long as possible. Once you're out of the college, if teachers guided you in college, who will guide you? If peers supported you in college, who will support you once you're out of the college? If your focus, the comfort of the campus, kept you going, working for the 5 years that you spent in the college, what will keep you going? It can't be just your goal, because life as it turns out will throw a lot of challenges. What do you think will be the guide, the support, the motivators? What will those factors be? You will have 101 goals, you will have 101 ambition, justifiably. But then who will support you? I may not be exaggerating that in saying that when you come out of the college and start building a career, no, it's like a steep climb, the roof climb where you see almost a 90-degree and if not a more tilt with all those footmarks, the pegs, the holes. You'll have to climb. And this is something that I would not hesitate to ask, because I've asked this question myself right through. And I can tell you very confidently that your guide will be the seniors, be it whatever, be it the corporate practice or the litigation or the judiciary, whatever that be, it will be your seniors that who will guide you. Now, seniors need not necessarily be under whom you work. Seniors could be all those who have been ahead of you in times in the profession that you have chosen, the walk of profession that you have chosen. I was a law student almost 33 years back, and I remember being keen to hear Sri Udayawala argue, and if I remember seeing him as a young law student interning with a senior, I remember seeing him as a lawyer fledging to find my own footing in the profession. I remember looking for opportunities to brief him to appear on my behalf, getting those opportunities. I have seen him as a fellow designate lawyer, of course much younger and raw than he was. And in the last 5 years or so, I've had the privilege of seeing him argue and see the craftsmanship that he brings to the profession. I do not exaggerate when I say he is a don in every sense of the expression. My suggestion is, when you go into the profession or start your career, please look out for your seniors. Make your choices and imbibe as much of qualities as you can. Now, if I'm speaking of Mr. Udayawala to a bunch of youngsters, I must speak about two parts of conversations that I've had with him. And again, after some years into the profession, as a young member, I could not go near sir, and he was extremely busy. I asked him one day that it was almost after he had put in 35-40 years of profession, time in profession. So you've seen everything, you have achieved everything. The kind of success that you have seen, maybe I can't even imagine. but you still work at 11 o'clock in the night, 12 o'clock in the night. You ask us to come at 12 o'clock, and let me tell you this, if sir said, shut down your office, close your office, come and brief me after you close your office, many of us who were told this wore it as a badge of honor. Because we would tell, really office that is, come after you close your office. And I also dare to ask you, no, success will need certain factors to work. So what would those factors be? Talent matters? Only talent, flair matters? Hard work as any place? His response, sir, madam, was classic. He said, talent is 1% success, hard work is 99% success. And he personifies that. And I'm sure when he holds the mic after I finish in a few minutes from now, he will share his experiences, and that will be motivation for all of you. And the second is Professor K. Suresh was mentioning. The kind of variety of matters that he handles, probably has handled over the number of years, is phenomenal. He gave you a list. Some of them I can't even repeat if given a list in writing. What does it indicate? Does it mean that everything, obviously it does not mean everything comes easy. What does it indicate? It indicates, according to me, that one should be open to receive as much as possible. When I say this, I only mean to say that as a lawyer, there is no limit to what you should know. You should be abreast of what is happening in different aspects of the society. Sir was mentioning just now, a few minutes back, that he handles divorce matters, he handles property matters. And his comprehension of what is happening in the society must be hands-on. In fact, it is said, law is an ocean which shores in many places. So you need to know as much as you can about as many subjects as you can. And how do you know that? You can acquire that kind of familiarity, that kind of acquaintance only if you have a good reading habit. And now when I say reading, it is just not reading a certain set of written material. It is a whole process attached to it. You read, you recollect, you converse, you discuss, and then it remains with you. So, my friends, I emphasize two things, the two thoughts that I mentioned when I began. Rely on artwork, and when I mean artwork, I mean read as much as you can, and on as many subjects as you can. If you could put in that kind of artwork, if you can take the quality of reading as much as you can on as many subjects as you can, I'm sure there will be many Hudayolas in the making here, and that's our wish. And Sir would be the first one to say that. He is a helping hand to many as well. Now, I've got a couple of things to say on the manner in which the participants take part in moot court. Now, we are all creatures of habits. You cultivate a habit, it's very difficult to outgrow that habit. In the court, as a lawyer I've seen, and as a judge I see, it's easy to make out who has participated in moot court and who has not participated in moot court. There are certain distinct markers that comes out. How much of that is a good thing and a bad thing is the next question. I'm not saying everything is bad. All I'm saying is maybe a few aspects requires to be thought over. One, it's not that you have to put out everything that you've read. It's not that you've got a certain thought and you'll have to put it out. That's not what is expected in the real world. And I now speak as a judge. What do I want when a lawyer is presenting a case before me? What do I want? Begin well, convey well, be clear. If there is a certain droning and you have missed me, then I missed your arguments. So you must cultivate those habits which enable you to open well. So when I say open well, you will have to plan your opening statement. And I'm not exaggerating, I know of many lawyers, seniors to me, who would have in the olden times, the tape recorder. I don't know how many of you are familiar with those kind of, they would keep the tape recorder there, record their opening statement, record what they had to say, play it back multiple times over, and then correct themselves. Opening is very important. Second, I said is clarity in expression. You must be clear in what you are conveying, and that clarity comes from what you want to say, the language that you employ, and of course the tone. Remember, it's called an argument, but end of the day, it's a conversation with the judge. So keep that, you will have your own individual style. One of the participants said in reply, wish the petitioner had spent this much time with the officers when the show cause notice was issued. Now, good response. My attention was caught. That's not prepared. It comes when somebody is completely involved. Now, then there are certain practices, and when I speak of these practices, I speak to the professors and I speak to the seniors who guide the youngsters when they come and participate. Certain typical manner of addressing the court, asking for leave. Now I'll ask you, how much of that happens in the real world? It would be difficult. It would have been difficult in the past, perhaps, because you won't have had the time to go and visit a court. Now it's no longer. You can log into multiple courts across country and see how the court proceedings happen. In moot court, you're training yourself to be a lawyer in the real court. So what you do here must be, if I can use the expression, mimic what actually happens in the court. So if all of you can watch those court proceedings, of course, some of us could fall short of your expectations, but that's all right. We will leave it that, so long as the outcome is good. Please, my request to all of you seniors, all of the professors who guide these students who participate in moot court, to pay a little more attention to this cliche presentation addressing the court. If you can avoid, and this must not be the first time that I'm saying this, and I've heard many people before me say this, if you can avoid it, becomes that much more pleasant. It's always wonderful to come back to campuses. It reminds us of the days that we have spent in campus, the hopes, the ambition that we had, and we walked through life to see how those panned out for us, where we made our errors, where we enjoyed whatever little success that could come away. It's an experience, it's an opportunity for us as well, because students from different states have come together, very keen students who would want to excel in law. To be talking to you people, to saying a few things to you is indeed a privilege. I thank the management for this opportunity. I congratulate all the participants. Thank you.
Thank you, sir, for your words of wisdom. I'm sure that was extremely enriching to the audience. Now I'd like to call upon Shri Uday Holla, sir, Senior Advocate and former Advocate General of Karnataka. Sir.
Justice Shyam Prasad, whom I admire most for the simple reason is one of the finest of judges that Karnataka High Court has. Let me share this with you. I had appeared before his father, who was also a judge, who had risen from the ranks. He was magistrate. I had appeared before his father, Justice Mallikarjun, one of the finest of human beings. I had appeared before him when he was a civil judge, appeared before him when he was a district judge, I appeared before him when he was a High Court judge. And the same trait I find in him. Therefore, that is the reason why I applaud, I always admire him. I have always said this: teachers are nation builders. All of us are inspired by our lecturers and our teachers. You have not even heard of that great man, Dr. Narasimhaya, who was my principal in National College where I studied. A Gandhian, unmarried, he was staying in a hostel. He dedicated his entire life for the cause of students, and I was inspired by him. And you have all these wonderful teachers here, and I must compliment them for this wonderful gathering that is all because of them. Well, friends, when I joined the bar, we were on the, not inside the class, but on the, not even the campus, on the playground outside. If you asked us about subjects of law, we didn't know. At the end, before the exam, a month before that, we would sit, study, and somehow scrape through. That was what was law about. And if you didn't get seat in medical college, well, the next was engineering college. You didn't get there? Okay, accountancy. No. Let's get into a bank job. Not possible. Join the law college. Each one of you have chosen this profession to become lawyers, whether it be litigation or whether it be corporate world. And you are the social engineers, because if you get into litigation, you are able to wipe out the tears of the litigating public, the citizens. The amount of thrill, the amount of happiness that you get, if you are able to wipe out even a single tear from an eye of a citizen, the happiness that you get is far greater than the riches of all that you can possess. As Justice Krishna in one of his inimitable style, in one of his judgments said, if I am able to wipe out the tear of one person, it gives me unbounded happiness. And let me tell you this, in litigation, you deal with diverse subjects, multitude of people. A time was there when some 20 years back, I had appeared for a factory worker. I was earning hardly, those years, today, when you go into the mall, as all of you are very fond of, the 500 rupee, 2,000 rupee note has no value. In those years, even 10 rupees was quite valuable. And there was this factory worker, I was able to get relief for him. In those years, I would charge 50,000 to 1 lakh a case. He came and told me, sir, I want to give you a fees. I said, no, I won't take it from you because you are a factory worker. He took out 50 rupee note and said, sir, this is all that I can afford, please take it. I said, no, but he said, sir, this is all that I can afford, please take it. And I said, yes. And that 50 rupee was worth 50 lakhs to me. That's what it is. Ultimately, here was a factory worker. For him, that 50 rupees was enough for probably 15 days of his livelihood. Litigation is something which is really ennobling. I am sure many of you will not join litigation because it doesn't pay, gestation period is too long. Yes, I also went through it. There was a time when I said, I have sold first take hours in post office because I didn't have money in my pocket after I started my practice. Despite getting first class, first rank, I thought I was better than Palkiwala, and after coming to the profession, I realized I knew nothing, I was zero. Knowledge. You know, you must have all heard about Stephen Hawking. You know, Stephen Hawking was one of the greatest astrophysicists, physicists that world had. He was on a wheelchair. He was on a voice synthesizer. Of course, he passed away a couple of years back. He said, universe, you know where the stars are, the stellars are, the suns are. Universe is so vast and wide that if you travel 1 million light years, you will not reach the end. Must have all read, you know, in high school that light travels per second something like 2 lakh miles or 2 lakh kilometers per hour. Therefore, that is the knowledge. What you know, what I know is a speck. Therefore, accumulate as much knowledge as possible. As Justice Shyam Prasad said, this is the time for you to accumulate as much knowledge as possible. That will stand you in good stead. I have dealt with engineering subjects. When I was the Advocate General, I had to deal with the Krishna Water Disputes Tribunal. I have cross-examined a witness who was a PhD from IIT Delhi on scientific principles on dam building, global warming, civil engineering, and I was able to show from my cross-examination that the scientific principles he had enunciated on behalf of the state of Andhra Pradesh was wholly fallacious. I was able to do it because I had the benefit of some professors, retired professors of Indian Institute of Science with whom I would discuss. That's why I said I've dealt with IPR, intellectual property rights, matrimonial cases, anything under the sun. That's why I said, you know, litigation is as diverse as life itself. I'm sure not many of you will come to the litigation, but you can't get a better thrill in life, better job satisfaction than getting into the litigation. Yes, it's a tough life, but the joy that you get, intellectual satisfaction that you get is far greater than being in the corporate world. Because in the corporate world, what you will do is, you will get into the net. Cut and paste job is very easy. If you come into the litigation at least for about 2-3 years, you are better off even as a transaction lawyer, because you know what are the pitfalls in the terms of the agreements that you will be drafting later. So my advice to all of you youngsters is, if you can come into litigation at least for about 2 or 3 years and then get into corporate world, you are better off even as a corporate lawyer. Well friends, 2 things I want to mention to you, those who had participated. 1990 I went to the US. I was in the US Supreme Court. You know, US Supreme Court gives time limit for each lawyer. Even the biggest of, the toughest of cases, not more than half an hour is given there, because it's all written submissions. I was sitting in the court hall, and one lawyer was arguing. Suddenly the red light was on. Halfway through the sentence, he sat down. Why I am mentioning this is, time is one factor that each one of you participants should bear in mind. You must focus. You must analyze your this thing. What is it that I will be arguing about? Can I encapsulate within this 5 minutes or 10 minutes that is allotted to me or allocated to me? That is very, very important. Because if you go to say moot court in abroad, they'll start deducting marks for you when you extend beyond the time limit given to you. You know, I've said this again. If only we Indians are the most brilliant mind. Look at NASA. 25% of Indians are there engineers as in NASA. 25% of NASA engineers are Indians. Who dominates the Silicon Valley? The Indians. Who's the head of global Google or Microsoft? Indians. We have as Indians, every one of us have that genes where we are brilliant people. But two things we lack. What is it? One, discipline. We lack discipline and therefore we don't follow the rules. Suddenly you will find, the red light is there, policeman is not there. Well, it's our prerogative and privilege and honor to pass through that red light. It doesn't matter. This discipline enables you to follow the rules. Second, in Switzerland, I have seen this personally. 9:50 in the morning, 9:59 the train was to leave the station. 9:57 the train came inside the platform. People got in. 9:59 to the watch, the train left. The train driver had that sense of time. That is discipline. 2, organizing capacity. You all see what is happening in India. McKinsey, one of the leading law firms in the country in New York, at one time it had something like 2,000 or 2,500 lawyers as partners. Imagine the resources that firm had, probably far greater than the budget of the Karnataka state. Here, 3 people joined together, third month they part company. Why I am saying this is, if only we inculcate discipline and organizing capacity, I think we will be able to rule the world. You youngsters will have to now bear that in mind. You are the torch bearers of this country now. We are past. We have messed up the country. But you, each one of you, are the future of this country. If you are able to inculcate into yourself discipline, organizing capacity, each one of you take a note that I will abide by the rule, that I will be more organized. I'm sure country will progress enormously. We have great potential. We have a civilization which dates back to 5,000 years. But as a nation, we have failed. Why? Because my generation has failed, not because of you. Today, you are the torch bearers. Therefore, please, as youngsters, acquire as much knowledge as possible. Inculcate more discipline into yourself. And remember, you are the future of the nation. If each one of you discipline yourself, if each one of you take oath that you will be the torch bearer of this country, I'm sure the country will be number one without any compunction or without any hesitation. I can say this. Well, I can only say this, at your age, I wouldn't have had the guts to come and speak 2 sentences. I must compliment each one of you whom I have seen here. Your performance was exceptionally well, especially when I heard that you were all first year students, one of the teams. It's really heartening. That's why I said, for me, coming and seeing the youngsters do so well is really heartening. At my time, we didn't have moot courts. We didn't have court attendance, nor did we go to lawyer's office. We were, as I said, loitering on the playgrounds. Well, friends, you have a great future. Please, you have such wonderful facilities. You have such wonderful teachers to teach you. Make best use of it. You have a great opportunity. You know, US is a lawyer-driven society. We are slowly inching towards it. India is also inching towards it. Therefore, there's a lot of potential for lawyers. And please make the best use of it. I wish you all the best. Thank you very much.
Thank you, sir. It was a pleasure to hear you speak. You are an inspiration to all advocates and law students alike. And now, for the moment we've all been waiting for, I can say with utmost certainty that all of you have one question in mind: the results of the competition. So without any further ado, I'd like to call upon Shri Surana, Advocate and Head of Academic Initiatives, Surana and Surana International Attorneys, to address the gathering and announce the results. Sir, please.
Honorable Justice Mr. B.M. Shamprasad, Judge, High Court of Karnataka, Shri Uday Holla, Senior Advocate and former Advocate General, Government of Karnataka, Mr. Y.C.S. Swami, Commissioner of Appeals, Commissionerate, Mysuru, Professor K.S. Suresh, Chief Executive, JSS Law College, Professor S. Natraju, Principal, JSS Law College, Mysuru, Mr. Achutan, Mr. Kartik Ranganathan, Mr. Professor M.P. Nagendra Murthy, Chairperson of Moot Court Committee, distinguished guests of the dais, professionals, chartered accountants, company secretaries, lawyers among the audience, Moot Court conveners, coordinators, learned faculty members, academicians, scholars, students of JSS Law College, and my dear participants. It is my privilege and pleasure to welcome you all on behalf of Surana and Surana International Attorneys on this valedictory ceremony, and a privilege to share the dais amongst the luminaries. Just when Shri Uday Holla was mentioning that you need to keep time, keep the constraints of time, have that in mind and work. This reminds me of my senior, when I went with a 6-page note. He said, you must give it to me in 1 page. I said, how can I do 6 pages in 1 page? I have written 6 pages and you want me to do it 1 page? And when I did that exercise, it took me a lot of time. But the thought behind is that you are able to articulate and convey what you have in that precise what is required by the judge. And I think that is a winner, as what Shri Uday Holla has guided us, and that is something I have experienced myself. Nurturing academic excellence has been a part of Surana and Surana International Attorneys, and for the past 2.5 decades, our foray into moot court competitions, judgment writing competitions, arbitral award competitions, and essay competitions has yielded satisfying experience in helping improving research, writing, and argument skills of the participating students, besides sensitizing them on issues of law. This is a comprehensive platform which was created for the students to develop into a full-fledged professional, and now it is the world's largest moot court program, or moot court project if I should mention. This landmark would not have been possible without the continued support and participation of all stakeholders, and this milestone is something which inspires us to move forward, and we look forward to all the stakeholders for their continued support, guidance in carrying forth the academic initiatives which our firm started, and we hope to bring new formats into as part of legal education. I take this opportunity to thank members of the bench, the bar, senior counsels, senior advocates, senior counsels, our distinguished moot court advisory board, who over the years have had 50 distinguished members of the bar and the academia. We are fortunate to have Sri Fali S. Nariman as a chief patron. During the celebration in Delhi last March to commemorate the 25 years of the Surana and Surana Moot Court project, a galaxy of leaders from the bar and the academia came together to deliberate important aspects of legal education in the present and the future. The following 4 points arose: simplification of language and use of anecdotes for effective oral and written advocacy, a mindset of conflict management and resolution required to present legally and practically acceptable solutions. Third, the use of technology in law practice and adjudication. And last but not the least, the thrust on policy advocacy for greater awareness, original thinking, and leadership development. I would just briefly touch upon the first 2 points due to the time constraints. First, the simplification of language. While all the beautifully educated people with elegant spoons in their mouths of grandiculate words in speech or writing, and systematical documents have been relevant, and we can still jargon on big, wonderful, pleasing Chaucer, Wordsworth, or Shakespearean vocabulary. The point was of its relevance in the future. The changing face of society, which is based on inclusive democracy, particularly for people who speak English as a second language, people with disabilities, and those with lower levels of education, indicates that the world will move more to plain, easily understood language when communicating. This stems from the fact that people have a right to understand what they are being asked to do, what are they entitled to, and what their rights are. It is ironical that we have had a peep into the future sometime during the last quarter of the previous calendar year, when New Zealand has bid its farewell to the jargon and introduced the Plain Language Act. The big question was to be or not to be, and the to be got 65% of votes. and the bill ultimately passed with support from the Labour, Green and Maori parties. Henceforth, New Zealand will use only plain language in its bureaucracy. Plain language advocates have said that the bill would save a lot of time and that clear communications are very important to and a key to a functioning democracy. Other submitters argue the bill would improve accessibility for the people. Back home, the Society of Indian Law Firms has been for the last 1 year propagating the use of plain simple language as well. The second point was as regards the mindset of conflict management and resolution, and it was thought that the resolution should move to practically, legally and practically acceptable solutions. Historically, conflict in India was what we called ADR today, where self-government existed in the form of panchayat, where 5 elders of a community in a town or a village would go about effectively resolving issues, which was a non-adversarial approach rather than the adversarial approach that we follow today. Hence, from the traditional and the historical perspective, this has reversed as we have adopted the adversarial approach in the form of litigation and arbitration, which is actually the ADR, and not what we term ADR today as mediation, conciliation or negotiation. A modern adopted approach is from foreign civilization and culture, and that's not how it was prevalent in India. The panchayat used to make the parties involved sit together, resolve the dispute, and would ensure that they break the barriers and bridges over a meal, rather than the adversarial approach today, where the bridges continue to persist, and the approach is more on a win-lose perspective than a win-win perspective. I would end here with a food for thought, for it is upon us to decide our future course and what approach we hand over as the baton. I would now move to announce the results, which I'm sure the teams have been waiting for. I'm told that some of the teams are traveling right this evening. So without much ado, I will announce the results. I would request Mr. YCS Swami, Commissioner Appeals, to please come forward on the stage and give away the memorials. We start with the memorials. The fourth best memorial is shared. The teams, please come forward as soon as I call you. CL15 and CL4. CL15 is the National Law University, Jodhpur, consisting of Ocean Beniwal, Pravit Veer and Sarma Anil Patel. They share this fourth best memorial university. That's the team at the back, the all-girls team from School of Law Christ, Utsa Koti, Manushri and Vritti Singhvi. No, please. Third goes to Team CL1, Government Law College, Mumbai. Ashraya Beg, Gayatri Bhansali, and Chetan Kandhi. Please come.
Sir, Kamala is the leader who is collecting. And who's the pay?
The next team, the second best memorial. They take home a cash prize of rupees 5,000. Please come on the dais. Please come on the dais. Next, the best memorial goes to Team Code CL25, Army Institute of Law, Mohali, consisting of Shrishti, Jha, Swati Pandey, and Janvi. They take home a cash prize of rupees 10,000. Thank you, sir. Please take your seat.
Chetan Kandhi and Gayatri Bhansali representing Government Law College, Mumbai. CL2 is Deepthi Damodaran, Ranjini and Jeenu Rashid representing Alamin Law College. CL3 is Venumurugan, Aranya and Nancy Victor representing JLC, Madurai. CL4 is Utsa Gwati representing Christ Law College, Bangalore. CL5 we have Shubman Singh, Siddharth Sengupta and Shruti Patra representing NLU Odisha. CL6 we have Himani Bed, Dimple Kotele and Apurva Sinha representing Amity Chhattisgarh. CL7 we have Elima Fatima, Advait Upadhyay and Rishta Rai representing Lloyd. CL8 we have Pavas Yanigiri and Priyansh Sharma representing Pandit Ravi Shankar University. CL9 we have Sakshi Sharma and Monish representing NLIU Bhopal. CL10 we have Aditya Jain, Namisha Chaudhary and Raghav Sehgal representing RG and UL. CL11 we have Aditya Kumar, Mehak Agarwal and Purvi Mittal representing Symbiosis Law School. CL12 we have Ishan Ganesh, Deepraj and Amartya Ashish representing Navalma Filodia. CL13 we have Priyanshi Raj, R. Sharma and CL14 we have Ishika Bosi, Kunal Kamal and Ashprita Patnik. CL15 we have Pravit Veer Sharma, Anil Patil and Oshin Beniwal. CL16 we have Nitish Kumar, Sejal Agarwal and Vaiman representing MNLU Nagpur. CL18 we have Ronak Ali, Samit Siddhanta and Roshni Jaiswal representing SNS Nagpur. CL19 we have Angelina Rochelle, Akshat Aran and Akanksha Pillai. CL20 we have Prajot Tatye, Pradeep Kumar and Avantika Deshpande representing KLE. CL21 we have Vidya Sharma, Jumana Kazel and Balakrishna representing. CL22 we have Krishna Kant, B. Divya and Angeline Sudiksha representing GMC Weber. CL23 we have Arvind Prakash, Mahima Jain and Aishwarya PS representing Cochin University. CL24 we have Anjali Kumari, Yashwant CR and Kushi Gupta representing University Law College, Bangalore. CL25 we have Shrishti Jha, Swati Pandey and Janvi Bansal representing Army Institute of Law, Mohali. And CL26 we have Nikita Susan Eapen, Amulya Prasad and Rohan Kakatkar, a non-compete team representing JSS Law College.
Best Student Individual category, and this Best Student Advocate category is based, participants know, but for the audience, this is based on the preliminary rounds. Who are the Best Student Advocates? I would request Sri Uday Hola to please come forward and give away these prizes. Please sir, you can be there. I call upon the first team, Team CL6, Amity University, Chhattisgarh, Dimple, the fourth Best Student Advocate. As the third Best Student Advocate from Lloyd School of Law, Noida, Team Code CL7. Next, for the second Best Student Advocate, I would invite Himani Baid from Amity University, Chhattisgarh, CL6. She wins a cash prize of rupees 5,000. The big one now, the Best Student Advocate with a cash prize of rupees 10,000 goes to Anil Patel of National Law University. This is the team code with CL15. Thank you, sir. Come this side. Now the runners-up, Ilima Fatima, Advait Upadhyay and Rishita from Lloyd School of Law.
Okay.
winners, please come out. Priyanshu, Arush and Gaurav Kothari.
ಹಂಗೆ ಕೇಳಿ ಆನಂದ್ ಸರ್ ಹಂಗೆ ಸರ್ ಹಂಗೆ ಕೇಳಿ ಸರ್ ಆನಂದ್ ಸರ್ ಒಂದು ಸೈಡ್ ಸರ್ ಹಲೋ
University CL13. Congratulations, Priyanshu. I would request Honorable Justice to please do the honors. The last announcement is for an award which we call the Spirit of Surana Award. This award lays down high standards and ideals in mooting. This is given to the team which represents excellence of intellect and astuteness in argumentation, participates the competition in goodwill and harmony with team solidarity in a spirited and healthy competition. And as per the votes received and with the veto of the Moot Court, student Moot Court committee members of JSS Law College, this Spirit of Surana Award goes to the team CL21 from Sastra, Tanjavur, Yash Kumar, Jumanna and Valedictory. Please come forward. I will request Honorable Justice Mr. Shyam Prasad, please give away the award.
Sir.
To acknowledge and recognize the contribution which JSS Law College is doing. We are partnering with them for now 12 years for this very competition. We would, from Surana and Surana, would like to give a certificate of appreciation to the institution. I would request the whole team, I would request the principal, the chief executive, and Professor Nagendra Murthy and the Moot Court committee members to please come forward and receive this from Shri Uday Holla. Sir, I would request you to please give this.
Sir.
We now culminate, and before I wind up, I would like to convey our gratitude to Honorable Mr. Justice D.M. Shyam Prasad for being magnanimous and sparing his valuable time to be here and deliver the valedictory address. The wisdom shared by him is a guidance to all those young students present here. Our gratitude, special gratitude to Sri Uday Holaji for his benevolent presence and words of inspiration to young students of law. Next, I would like to thank on behalf of Surana and Surana to all the judges. This is one moot where it's not only legal professionals who come in to judge, but we have the chartered accountants, the company secretaries who also come and contribute as a stakeholder in this competition because of the subject. I thank each and every one of them for the time and effort. Professor K. Suresh, Chief Executive, Professor S. Natraju, Professor Nagendra Murthy sir. We have had so many judges. I must mention that we had 4-5 rounds and they have been with us and judging special, without which this competition would not have been possible. The student coordinators, the back team who have been relentlessly and tirelessly working, Tapo, Viresh, Arya, Shama, Smriti, Hima, Shashwati, Shivani, and whole lot of others who have been tirelessly working and contributing and helping me and the committee members. They themselves, some of them are the committee members, and a whole lot of other student volunteers. The staff, of course, the academia, the students, and the media persons who have been here and covered this event. And last of all, the participants for being here entering this competition. And a special thanks to my colleagues back in office, Deepa and Mridula, who are actually do all the work, and I just come here and speak a few words and go away. Thank you, Deepa and Mridula. Thank you, everyone.
Thank you, sir, and a hearty congratulations to all the winners. Now I'd like to call upon Srimati Sheila Ganesh to deliver the vote of thanks.
Now, on behalf of JSS Law College, Mysore and Surana International Attorneys, I am here to render the vote of thanks to this august gathering. Firstly, I render my deepest gratitude to Honorable Mr. Justice B.S. Shamra sir, Judge High Court of Karnataka, for gracing this occasion, judging the finals, and also giving valuable valedictory address. And thank you very much, sir. Now, simultaneously, I request Shri Uday sir to honor and felicitate our
Anand sir.
With sincere thanks to Shri Uday Senior Advocate and former Advocate General of Karnataka, for gracing this occasion, judging the finals, and also presiding over this event with his informational advice, Shri Uday Thank you, sir. Further extend my heartfelt thanks to Shri YCS Swami sir, Commissioner Mysore Appeals Commissionerate Mysore, for his support and being part of this event. Thank you very much, sir. Kindly accept the Thank you, sir. Next, I render my sincere thanks and profuse thanks to Shri Surana, Advocate and Head Academic Initiative, Surana International Attorneys, Chennai, for coordinating and helping us throughout for the. Thank you very much, sir. Further, it's our bounden duty to profusely thank thank Sri Karthik Ranganathan, alumni as well as the standing senior counsel representing Income Tax Department at High Court of Madras for his long association with the college and also for drafting this tasking moot proposition. Thank you, sir.
Out Mr. Karthik Ranganathan, without whom this competition would not have been possible. He is the drafter of this wonderful moot proposal. My apologies to him and to all of you for not mentioning it earlier.
Also, we are profusely thanking our Chief Executive, Professor K. Suresh, sir, for his constant support and inspiration for organizing such events. Thank you, sir. I also render my sincere thanks to our beloved principal, Dr. S. Nataraju, for his all-round support for this event. Also, a sincere thanks to the dignitaries of the directors who have taken part and for the smooth conduct of this event. Thank you one and all. And further, my heartfelt thanks to the participants, who are the extreme stakeholders of this event, for participating and coming all the way from different parts of the country, for participants, the winners and runners, etc. Thank you one and all. Likewise, I'll be failing on my duty if I don't thank our Moot Society members, the core committee members, the entire team, the battalion, we can say, the committee members, the volunteers for given strenuous support for the smooth conduct of this event. Thank you one and all. Likewise, the Moot chairperson, Professor M.P. Nagendra Murthy sir, has shouldered this mammoth task and has made it a grand success. Thank you, sir. Further, I extend my heartfelt thanks to the students of our college, staff and faculty members for the constant support and for coordination with the program. And finally, the press and media also thank at this moment. I thank one and all.